Okay, I think we will begin. Good morning, everyone, and welcome to Eckstein Hall and Marquette University Law School, a building dedicated by Justice Antonin Scalia, among others. This room, our Lubar Center, where we do so many of our public events, has seen Justice Elena Kagan and now Justice Brett Kavanaugh lead events, including variously the Jenkins Honors Moot Court Finals, conversations on the issues with Mike Goucher, and our annual Hallows Lecture. So the room, though less than 10 years old, has a history. For one of its first events in 2010, Scott Walker and Tom Barrett, watched by a statewide audience, debated during their race for governor of Wisconsin. And it was here, less than 2 years later, as again broadcast across the state, and now with national attention, they debated a second time, days before the extraordinary 2012 recall election. It would be futile to try to list all the debates, distinguished lectures, conferences, CLEs, poll releases, or public conversations that we have hosted here since then. I will say that this room reflects, and I hope, honors Shel and Marianne Lubar's confidence in prompting us to establish and in endowing the Lubar Center for Public Policy Research and Civic Education. In these circumstances, I hope that you will join me as we get going in a round of applause for Shel Lubar, who is here with us this morning as frequently. Shel, your and Marianne's generosity is having an enduring effect on this law school and the broader community. We are most grateful. Thank you. Some of you familiar with my ways may find it surprising that I should be here this morning. It is Monday morning during the semester, which means that Tom Schreiner and I ordinarily would be upstairs in class teaching advanced civil procedure every spring, with the fall course being this semester, as often, federal courts. The specific courses are worth mentioning because they are so different from one another, and they will help me introduce a point. Advanced civil procedure involves a strong focus on the text of various rules. Yes, we use the case method, and one needs the judicial decisions to exemplify and elaborate upon the rules. But the text of the rules of civil procedure frequently does take one a good way down the road toward answering a question as to how a court proceeds with a case and why. Federal courts sound similar and also involves litigation, but as an area of study is a very different animal. It is essentially an upper-level constitutional law course, and the amount of authoritative text available to us and the students, available, that really is to say, to the Supreme Court as it makes law in this area, is minuscule. To be sure, there is Article 3, and there are doctrines whose source we can try to locate in the text of the article. Yet the phrases, the judicial power of the United States, cases and controversies, and even questions arising under this Constitution, the laws of the United States, and treaties, those all being essential words of Article 3, they tell us only so much, as seems a polite way of saying damn little. So what do we tell our students about the bases for the court's decisions? In essence, we learn together that the court engages in a common law process as it fashions the law of federal courts and of federal-state relations, those being the areas of constitutional law embraced by our course, as it articulates the principles of separation of powers or federalism required for a particular case. We take comfort in the fact that the general common law process will be familiar to these upper-level students from their first year of law school. There is a reason, even beyond their private law importance, that torts and contracts remain first-year courses at this law school and every other law school with which I'm familiar. They introduce students to the reasoning process that will inform much of the law that they study and use, including constitutional law. To refresh our students' recollection, we give them the first page of Oliver Wendell Holmes' classic work from the late 19th century, The Common Law. It is Holmes at his most brilliant and incisive. I will relate only 2 sentences. The life of the law has not been logic. It has been experience, the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men have had a good deal more to do than the syllogism in determining the rules by which men should be governed. That this equally explains much of constitutional adjudication, we have no doubt. Consider, for example, the even more succinct statement by Holmes, 40 years later, now as a justice of the Supreme Court. A page of history is worth a volume of logic. The context prompting the aphorism from Holmes was a case of constitutional law. None of this is some contested ideological point, something that divides, say, living constitutionalists and originalists. Besides the page of Holmes, the only other supplement to our lengthy textbook that we give our students is also a single page, really a single sentence. It is a statement by Robert Bork as a judge of the D.C. Circuit, as quoted by the Supreme Court in 1984 in Allen versus Wright, a standing case. Quote, all of the doctrines that cluster about Article 3, not only standing, but mootness, ripeness, political question, and the like, relate in part and in different though overlapping ways to an idea which is more than an intuition, but less than a rigorous and explicit theory about the constitutional and prudential limits to the power of an unelected, unrepresentative judiciary in our kind of government. In short, it is well established from Holmes to Bork to all relevant others that the intuitions of judges and justices are awfully important to making and explaining the law. This reality all by itself makes the case for a poll about the Supreme Court overwhelming. To understand the law requires understanding the court, and understanding the court requires a sense of, for example, the intuitions of the justices, even the prejudices, often held in common with the society which they serve. I say, for example, because so much more than these intuitions or prejudices or opinions is relevant to the development of constitutional law, even beyond the other phrases that Holmes used. It would be useful to know, for example, what the law-trained elite think about particular points, to borrow a phrase from Justice Scalia. He did not really mean the phrase as a compliment, by the way, but that's irrelevant here. In all events, even apart from the basic proposition that the federal judiciary's legitimacy, like that of the rest of the government, depends upon the consent of the governed, to use a phrase from the Declaration of Independence, this poll will reveal a good deal that may help explain why the court proceeds as it does. The poll seems to me extraordinary. It is exclusively dedicated to measuring opinion about the third branch of our federal government and ranges broadly and deep. I would tell you more about it, but there's no need. Charles Franklin, professor of law and public policy here and director of the Marquette Law School Poll, is at hand. Professor Franklin likely requires little introduction to you, but I will say that before he joined us some 6 or 7 years ago, he served as professor of political science, first at Washington University in St. Louis, and then at the University of Wisconsin-Madison. His area of academic expertise includes study of the Supreme Court of the United States. He will give some important context for a few minutes, and then he and Mike Goucher, distinguished fellow in law and public policy here, will survey some of the results of the poll. After a break, there will then follow 3 panels, primarily involving first, academics, second, members of the bench and bar, and third, journalists covering the court. Some of these people will be more or less familiar to you. Others will be individuals who have not previously been to Milwaukee. We will introduce them as we go along, and for the most immediately practical point I am making this morning, we will take a break after each session. Charles.
Thank you. Thank you all for being here. I appreciate such a good turnout so early in the morning. Thanks to Shell and everyone else who's come into town from outside. I'm going to just set this up a little bit, and Mike and I will spend the time, as we always do, laying out the results of the poll. But I thought a little introduction is useful, and not the least because I come at this as a political scientist, not someone trained in the law. I think a majority of you are, in fact, trained in the law, and so you know the details of the Constitution, of the history of law, of common law, and all the forces within the legal world that shape the law. But I, a poor political scientist with just the tiniest bit of law classes in my background, don't. And in that, I'm a little bit like our fellow citizens. People who are affected by the law are concerned for the politics of the Supreme Court and the federal judiciary, but who are not learned. Every now and then I get the impulse to opine about a legal detail, and then I look around at my colleagues here and think, silence would be the better part of discretion here. And yet, we live in a republic that ultimately vests authority with the citizenry. And that citizenry must make decisions based on whatever understanding they have of whether it's the law or legislation or the executive. Without the benefit of the legal training that many of you have, without the time or the inclination to delve deeply into the structure of the law, the philosophies that might guide it, the principles of interpretation and decision, which professionals may use and see as important. What that means is that we rest the authority of ultimate decision through elections of a president who nominates, a Senate that confirms, in the hands of folks who are not likely to be able to judge decisions on the niceties of a statutory interpretation, but who are naturally more concerned with outcomes. Now, saying that you're concerned with the outcome of a decision in some circles is a rather dirty characterization of judging, that it should be based on principles in the law and norms of how you interpret those things. But I'll at least urge you that a republic needs citizens who are satisfied with the outcomes, because fundamentally they are not caught up by how you got to the outcome, but rather what that outcome is. This is a very different concern and interest. If we were having a panel on the Supreme Court and its decisions in the last term, we might very well follow a radically different path in understanding what the court had done. But from the point of view of the public and the citizens' understanding, we're going to take my path, the path of a public opinion survey. So we set out to learn how much or how little the public knows about the court and its decisions. We talked to 1,423 national adults in the 50 states, a national probability sample of the population. That has a margin of error of 3.6 percentage points for those of you who are counting on those things. And as always with our data, the full methodology report and things like that are be posted on the web, so you can find out how they were done, including the complete questionnaire and the complete set of answers. So in the end, I think the core of the issue for me is that the real work of the court is inaccessible to those not trained in the law, yet a republic rests on the consent and, to some degree, the understanding rather than blind faith of the public. And so odd as it may seem, the public does get to judge the judges, at least at one or two removes. And how they manage to go about judging the judges is what Mike and I will now talk about. So we will move on to the results. Dare I say, to the outcomes.
Good morning, everyone. Glad you could be with us today. We are going to do business today the way we do on the release of just about any poll that we do here at the law school. We do it in public, and Charles and I have a conversation about the results. So that's the format that you'll see today. If we have any time at the end, we'll try and take a question or two. But I think much of the next hour will be taken up with Charles relating the results of the national survey for us. So, Charles, let's begin by I guess, talking about perhaps the most important part of this survey, and that is the level of confidence that the American public has in the U.S. Supreme Court. Let's begin there.
This is a common starting point, and we'll start here, too, is if the public doesn't believe anything right about this court, then that's a problem. So, like so many surveys, we asked, how much confidence do you have in the U.S. Supreme Court? And here's the distribution of that. You can see that most people are kind of middling in their support. 43% take a some confidence, but an additional 29% a great deal, and 8%, quite a lot, and 8% a good deal. I think maybe it's worth pointing out that the bottom end of confidence is quite low, though 1 in 5 are somewhat jaundiced about the court. So that's a point of some concern.
But these numbers are far better than the confidence levels we have in the other branches.
Well, I grew up in Alabama, and we were always happy for Mississippi because it gave us someone to look down on. You might say that of the court and especially of the Congress. So the court is still in this sort of brownish color. The Congress is purple, and green is the presidency. We say the presidency, though it's a little hard to separate. But what you can see here is, let's pick on the Congress for a second. A great deal of confidence, 2% for Congress, 8% for the court. Quite a lot, 8 for Congress, 29 for the court. And even here in the middle, in the some confidence, Congress doesn't quite manage to reach the heights of the court. With the presidency, there's a little bit of bifurcation. There's a group that are pretty confident, a group that's pretty not confident. I think that has a lot to do with the current polarization over the president. But this is in line with what we've seen with other cities. So on balance, the court does pretty well.
You lump some of these numbers together.
Well, it's convenient to quit talking about all 5 categories. So I'm going to put the bottom 2 together, the middle one by itself, and the top 2 together. And then you get this, which also makes it a little bit clearer, that high confidence out here for the court, the top 2 categories, at 37 is bigger than with the presidency and a huge amount bigger than it is for Congress. And look at the back end, the very low confidence, that 20% have low confidence of the court. But it's much higher for both the Congress and the presidency in the low confidence category. So relatively speaking, the court's not too bad.
And again, just to reinforce, the most confidence, it's not even close. The most confidence.
That's right. In the high end, it's there. Also, when we say, well, choose a branch that you're most confident in, now there's not even a contest. Now the court is far and away at 57%. The branch people pick as the one they have the most confidence in. I'll pause for a second here to preview where we're going. A question might be, why? If you think of citizen control over the Congress or over the presidency, the direct use of the ballot is surely a greater control than the indirect method of controlling the courts. And yet people don't see those elected bodies as the ones they have the most confidence in. I'll just give you a hint. Possibly it's because they don't think those bodies are close to them in a variety of senses, political, ideological, and policy-wise.
How is confidence affected, Charles, by how closely people pay attention to politics?
This is one of the key things that we want to look at throughout the presentation. I already mentioned earlier that most people don't have deep, detailed knowledge about the court. But what does it matter if those who know the most think the least? Or conversely, if those who know the most think the most? Well, it turns out it's more the latter. This is looking at general attention to politics, so you can get low attention, middle attention, or high attention. And you can have low, middle, or high confidence. So look at the green bar, the percent with high confidence. That's the lowest among the people who pay least attention to the court, to politics generally. It goes up for middle attention, and it rises to a peak for the highest attention folks. So what this means is the people that are paying more attention to politics, and I could replace attention with interest in the court, knowledge of the court, and some other things. The patterns are very similar across those different measures of involvement with the court, or politics more broadly. It means that those who are most involved actually also have higher levels of confidence. You might imagine insiders being quite jaundiced, but it's actually just the opposite. Those who are following, are paying attention, generally are pretty confident about what they see rather than doubtful.
How does party affiliation affect confidence?
Well, now here we get into those political science-y things that politics raises its ugly head here. And what you see over here to the left among Republicans, again, focus on the green bars, but if you want to be a contrarian, you can look at the purple bars. But the green bar of high confidence is highest among Republicans at 54%. It then drops off as we move to people who are leaning to the Republican Party. It's actually quite low among independents, flat among lean Democrats, and then it actually rises a little bit with strong Democrats. But from left to right, you can see that Republicans are currently more confident with the court than Democrats are. And there's a little bit of interest in the independents who are not as confident as partisans might be. But party does matter here. Now, how could it be otherwise when you think of the way the judiciary, judicial appointments have become more and more a flashpoint of political battles, at least since the early 2000s, but that would be generous not to push it back into the late 1990s or 80s. You can pick your point. Carl Hulse will talk to us today later, including about his book on appointments and how incredibly polarizing and partisan those have become. So the public reflects that elite controversy in its perceptions of the court along partisan lines.
So we're talking party here. What about political ideology? Similar, but there's a point of distinction there.
Party and ideology are cousins, but they're related but not identical. When we look here, you can see that on the poor choice of scaling, I have conservatives on the left, but just break out of your stereotypes here. So 52% of very conservatives have high confidence, 31% of very liberals do. It's relatively steady in its drop-off here, or look at purple, low confidence rises as we go from left to right. Again, reflecting the typical battles of nominations and over decisions.
Important point, Charles, the perceived ideology of the court.
And here, I think the question is, we've seen these battles, we've seen both sides argue that the Republic's fate rests on their side winning the next nomination. The public, though, doesn't see it quite in such stark terms. This is the perceived ideology of the court. From very conservative to moderate to liberal to very liberal, where would you say the Supreme Court is today? And I think the thing that leaps out of this is how few people see an extreme court. Very few, 6% extremely conservative, 3% extremely liberal. You'll see that pattern repeated in other analysis as we go forward. It's not simply that people pick the middle of the scale without any further meaning, but it is that whether it's a centrist court as 50% C or a bit conservative as 33% C, or maybe some that perceive it still as a liberal court, we don't see a U-shaped pattern with voters seeing a court that's far to the right or far to the left, but rather one that sees a sort of middle that tilts a bit to the right currently, though I'm sure if we had done this in a different era, we'd see it tilt to the left.
Let's talk about the attention to politics factor again. If people pay less attention or more attention, how does that change those numbers?
Well, as you might not be shocked to learn, those who pay the least attention are also those who don't differentiate the court much, see it as a moderate court, again, with maybe the next category being a little conservative. But importantly, again, you see no evidence of extreme views of the court. As attention goes up, more people see the court. I'm having a little trouble getting my pointer to highlight, but from 24 to 29 to 41% see it as a conservative court, but again, not an extremely conservative court. And even for the highest attention, it's an even divide between a bit conservative and moderate. So the same pattern that we saw before holds, but I don't think informed observers, such as yourselves, would be shocked to learn that more informed people see the court tilting more to the right at this point, but not extremely so.
Does party ID move those numbers?
You would not be surprised to know that it does, that Democrats are more likely to see the court as conservative. But notice, even among strong Democrats, it's 42 conservative, 38 moderate. So that's 80% that see it as center-right. And again, a group that, as with very liberal folks, you might imagine would exaggerate the distance ideologically. It's only 8% that think it's very conservative, even among this group that might have strong motivations to perceive it that way.
Charles, we asked people how important they felt the next appointment to the U.S. Supreme Court was. Yeah. What did we find?
Well, pretty important. 47% say very important, and 31% say somewhat. And then you get a drop-off with about 22% that say not so important or not at all. We asked an open-ended follow-up to this question about why do you think it's important or not important, and it wouldn't surprise you that the very important folks have stories based on the ideological direction or tilt of the court, and they may like that or dislike it, but they express it in those ways. But this 20% or so, 22% in this case, who think it's not so important, have a real characteristic of personalizing it and saying, well, I don't have anything that's going before that court, or that court's really not going to affect me as part of this. And I think that says something about the distance in people's lives between their ordinary daily experience and what happens in the Supreme Court. Those of us intensely involved in the court may very well believe that the ramifications of a decision sweep through the society. But certainly for this 22%, those ramifications pass over them now, even if they may be affected by them, but without them being particularly aware of it.
So those are the people who pay less attention?
They are indeed the people that pay less attention. And if we look at that importance by attention, look at this, 70% of those who are high attention say the next appointment's very important. Now, there's a flip side to this. It means that the folks that are paying attention and are involved in the court are apt to amplify the disputes over the court. They're also more partisan. They're also more ideological. And so when we get fights over a nomination or fights over a decision, the folks that care the most are also a bit more polarized. But remember, they're more polarized about their preferences than they're polarized in seeing the court as especially extreme. Those folks that are not paying as much attention are not as interested, not as informed about it, and on the one hand, therefore, are less likely to mobilize about it, but on the other hand, could provide a reservoir that could be mobilized under the right circumstances, and that's maybe the downside for roughly a third of the public remaining inattentive and uninvolved and seeing the court as sort of moderate. You could imagine a world in which those things change. But as we are, those best informed are more politically and ideologically polarized, but they're also more confident in the court and think it's an important institution.
Charles, we asked about some potential institutional changes to the court. One thing that we've heard a fair amount about in this year's political campaign, the presidential race, is this notion of having more justices. How do people feel about that process?
Yeah, institutional change is one that's been looked at by political scientists who study this as a sign of the legitimacy of the court is being unwilling to change the institutions. But as we saw in the 1930s, institutional change comes up when intense conflicts evolve around the court. What we find here is that 57% oppose increasing the size of the court, 43% favor it, so there's a majority opposed, though it's a not trivial percentage that favor an increase in the court. Though, again, look at the moderation here. There are relatively few people in the strongly favor increasing the court group, and about twice that, 17% in the strongly opposed. So folks are not caught up on this issue. Again, we don't see a U shape. What we see is a hill. Not quite sure what letter is the opposite of U. I guess you shouldn't go down that line in public until you've thought it through ahead of time. But you see that this is a subject of intense political debate, but it's an intense political debate inside the family of folks really concerned about this.
There was greater public support, though, for this notion of limiting the terms of Supreme Court justice. Not a lifetime term, but limiting the terms.
And frankly, I was a little surprised at this. So a majority, in fact, a pretty sizable majority, 72% would put a limited term on the service of Supreme Court justices. I don't, frankly, have much of a notion about why expanding the court is less popular, but putting this limit on is more popular, except perhaps simply that there are not very many political offices with lifetime tenure. Doesn't hold for the Senate, doesn't hold for the presidency. Maybe folks just think, yeah, this is reasonable to limit the terms. It's possible that there's also some element of seeing old members of the court dominating decisions. Unfortunately, I didn't have the perspicacity to delve into that in great detail. So for the moment, let's suffice to say that of the institutional changes, a limited term is the one that stands out as more popular, though it also faces a long road to implementing any such change through legislation or constitutional amendment.
What about the notion of limiting judicial review? And maybe you should begin by saying, what do we mean when we say limiting judicial review?
Sure. So the question simply says, should the court be limited in the laws that it can review that Congress passes? Language like that. Earlier, and we'll get to it later in the presentation, we asked people about whether the court has the power to overturn acts of Congress that it finds to be unconstitutional. A surprisingly high percentage of people understood that concept and recognized it. So I think when we say limit the power to review, we actually are talking to a population that's aware that the court has that power. And they're fairly reticent to change it. 62% would not limit the power to review, though again, 38% would. And as we've seen before, the extremes are kind of limited. It's only 8% in that strongly in favor of restricting the authority.
Let's look at some of these potential changes, Charles, according to party ID. If you identify yourself as a Democrat, are you more receptive to the idea of that?
Right. So here we're looking at it by party on increasing the numbers. Purple, the dark purple, is strongly opposed. Let's just focus on that. So Republicans are much more strongly opposed. Fewer Democrats are strongly opposed. That's the party gap. Look at the dark green, strongly in favor, and you can see that it's very low among Republicans, higher among independents, but then actually drops off just a little bit among the two types of Democrats. Somewhat favor gets bigger, so together we get 42% of leaning Democrats in favor, 50% of strong Democrats in favor of increasing the justices. Though it's lovely and symmetric among the Democrats, they're actually evenly divided on this, and evenly divided in strength as well as not so strong support. So there's certainly a partisan gradient in support for an increase in the size, but it has not yet moved to clear majorities among Democrats in favor, and clearly a substantial opposition to a change in the size among Republicans.
On fixed terms, we found more of a broad base of support for that.
There's really almost no trend here. Again, for convenience, look at the dark green bar, and it's the same height across all 5 partisan categories. The dark purple is the same thing. So party really doesn't play a role in this issue of age. I think it could be that folks looking at the age issue have not seen it framed in partisan terms the way most of the proponents of increasing the size of the court right now are from the Democratic Party, whereas the age limits may not have been as branded by politics.
And the final one is the limiting of judicial review.
And so here we do see a little more Democratic support for those limits. Again, look at the green bar. It's not a big gradient, but there's some gradient across there. Bottom line, though, is party's not terribly strong here. So it's strongest in the size of the court, sort of intermediate, but not terribly strong here for judicial review. And it's basically utterly unrelated to change in terms of term limits.
Charles, let's turn to the confirmation process for a couple of minutes. And we asked a series of questions about when it's justified for a senator to oppose a Supreme Court nomination. Yeah. Why don't you walk us through those findings?
This is a totally non-controversial area, so we'll just go through it quickly. So 2 basic questions. The first is it justified for a senator to oppose and we include the language, an otherwise qualified and with no ethical problems, so we just take those issues off the table, nominee purely on the basis of them being from a different party. So you can see overwhelmingly 81% say this is not justified in this case, that party alone should not be an issue. The folks that have studied nominations will point back to a period, at least within living memories, where if and I'm talking about lower federal bench, not just Supreme Court, but if a nominee had the seal of approval of the Bar Association, they were rated as well qualified, there weren't other controversies, these folks would normally be confirmed with a unanimous vote, often just a voice vote. If it was a roll call, it would still nearly always be unanimous or close to it. Those days have changed. And in recent years or decades, the partisan divisions on nominees has become much greater. But are those partisan divisions or policy divisions? It's undoubtedly part of both. But here, from the public's point of view, purely party reasons is not sufficient. But when we ask about what I'm going to shorthand call policy reasons, but we frame it in the question as because of beliefs about how the nominee might decide cases. Okay? then there's still opposition on that, but now 38% are saying that those policy divisions are important enough to justify a no vote on a nominee, though still 62% say no, that's not a good enough reason either.
And the impact of party ID on these numbers?
Well, it's pretty flat on party. And as for whether you should block a nominee on party reasons alone, there's just no difference across party, just none. Okay? When we look at policy, there's a little bit more of a difference. It doesn't matter whether you look at the green or purple, but look at the green for a second. So there's some Republicans that think policy disagreements are a good enough reason to block a nominee, 37% among strong Republicans. That actually drops off with independents who don't think policy is a very good reason to block someone either. But then it rises among Democrats to be a bit bigger than it is among Republicans. 44% of strong Democrats saying policy reasons are enough. And again, under the current balance of President and Senate, you see that it's Democrats more concerned with this. At some point in the future, we'll have the natural experiment of a Democratic president and a Democratic Senate, and we'll see if the shoe's on the other foot. But these are modest differences, I would say, but they are in a direction that makes sense on policy, even though party reasons are not sufficient in any party.
Do those numbers change much if, for example, you think the next Supreme Court appointment is a very big deal? Do those numbers change much?
Well, maybe. So on party difference, those who think it's very important are a little more likely to say party is a good enough reason, 21% versus 15%. But when we go to policy, then there's a bigger gap. With those who think the next appointment is very important, now we're up to 42% saying policy disagreements are a sufficient reason. And so we do see some growth in that, but still some skepticism. The majority are skeptical that a well-qualified and ethical nominee should not be blocked on these grounds alone.
So our next question takes us back to 2016, and this is shortly after the death of Justice Scalia. President Obama nominates Judge Merrick Garland to fill that, and there is no hearing held on that. Republicans say we're not going to do that. We're going to wait for the 2016 election before we take up a Supreme Court nomination. How do people feel about that decision? Was it the right thing or the wrong thing to do to not hold a hearing?
So here in retrospect, a big majority say it was the wrong thing to do. 73%, 27% say it was the right thing to do. We are looking back at this several years later, and so it would be interesting to have a comparative study at the time. But it is clear that with the benefit of hindsight, 3 out of 4 say that no, blocking hearings on that situation was the wrong thing to do.
So fast forward to 2020. What if we had a vacancy on the Supreme Court in 2020?
As now that looms as a possibility, 69% say that we should hold hearings, but 31% not hold hearings during the 2020 presidential election year. And so, again, we don't have the data from, say, 2015, when it would be an opportune moment to have the public's views on hearings in a presidential year. But we can't put the genie back in the bottle here. We now look back on that and see 1 in 3 who would essentially say that in 1 year out of 4, we're simply not going to fill any vacancies on the court. One could debate whether that's wise policy or not.
How much does party affiliation move those numbers?
Oh, hardly at all. Okay, maybe a little bit.
But still.
So first of all, you will be shocked to know that Democrats think blocking Garland was the wrong thing by 87%. But it is interesting to look over there to the strong Republicans and see that a small majority, 55%, think that hearings should have been held. 45% were opposed to that. Now, this was a decision made by Senate leadership and supported by senators that allowed this to be the decision that was made. It didn't rest on public outcry that ahead of time that there be no hearings. Rather, the public's views were shaped by what they were told, what the explanations and the political rhetoric was. And it's clear that people chose sides on this issue, and they continue to reflect those sides. But it is, I think, still interesting that on the Republican side that benefited from that decision, there is still essentially an even divide or a slight majority opposed to that decision.
And in 2020?
And in 2020, here it's a little more interesting. Now, most Democrats think that you should hold hearings in a 2020 vacancy, but a sizable 38 or 37% say no. Remember, 87% think that in 2016 there should have been hearings. This has a little flavor of payback to me. That having been on the receiving end, at least 1 in 3 are not in the mood to be generous in a 2020 hearing. But there's actually a little bit on the other side as well. 28% of Republicans now say, no, we shouldn't hold hearings in 2020, even with the nominee of our party's president and with the Senate in control of our party. Turns out if you dig into that a little bit, a lot of that 28% seem to be people that were convinced by the McConnell argument in 2016 that you shouldn't hold hearings in a presidential year. And they continue to reflect that notion today. And so when you persuade your folks that presidential years are off limits, then some of them continue to believe that, even when it might benefit you. Now, should we have a vacancy, I'm sure that we'll see some reshuffling of this as leadership in both sides present their cases. But I just want to touch on this thing a little more heavy-handedly in that in the history of nominations within the Congress, you see how there's been a ratcheting up of the divisiveness over nominees as we went over the filibuster fights and then striking the filibuster for some nominees and now for all nominees and the partisan rancor that has gone with that. This is a little bit of a reflection of that, I think, in the public eye. Having declared that presidential years are off limits has some ramifications, partly on Democrats that you might say is just sour grapes and might go away if they had control. But it's more interesting that it's had some effect on the views of Republican partisans. And again, as I started this, you can't quite put the genie back in the bottle on this.
We wanted to get a sense of how the public felt about some major Supreme Court decisions and also how they felt about some potential possible Supreme Court decisions that could come in the years ahead. Charles, let's begin by setting this up properly. There were 7 past cases, 7 possible future cases.
Right.
What are we trying to do here?
So we're trying to describe cases in the language that people would encounter it in journalistic accounts. So we're not trying to describe cases in fine technical detail. We, in fact, made a deliberate decision not to identify the cases with the names of actual cases, with the one exception of Roe versus Wade, because it's hard to talk about that without mentioning that case. And so our descriptions, let me give you a couple of examples. So a hypothetical future decision, how much do you favor or oppose the following possible Supreme Court decisions? Strike down the 2010 health care reform law, also called Obamacare, by declaring it unconstitutional. That's not a case that's currently before the court, but it could easily end up there. And on cases already decided, the same lead-in, how much do you favor or oppose the following recent Supreme Court decisions? We took some liberties with the word recent. Establish a constitutional right for same-sex couples to marry. Decide that privately held for-profit companies may choose not to pay for coverage for prescription birth control for their workers' health plans if the company's owner has religious objections, and so on. I'm not going to read you all 14 of these, but I hope you get the relatively colloquial language, though we were at pains to reflect the way these cases were described in typical news coverage of the cases.
So let's talk about the 7 recent decisions first. I say recent in quotes. First one deals with the issue of corporate political spending.
Right. And so these are, I should say, these are arranged in the order of strongly favoring the decisions. So if we were to slip into this language, we'd mention Citizens United here. But the question says, allows corporations and unions to spend unlimited amounts of money for political campaigns. This is a very unpopular decision with only 3% strongly in favor and 11% strongly opposed, somewhat in favor. And then you get a total of 75% opposed to one degree or another with some pretty intense opposition. And here we invited people to say they don't know what they think about this decision. A lot of these may be very distant from people's attention, so we're explicitly giving them the option to say, I don't have an opinion about this. So here's a case where a major ruling remains quite unpopular. I think I can say long after it was decided, but at least quite a while after it was decided.
The use of race as one factor in college admissions.
This is a long-standing dispute since the Bakke case way back when. It, too, is very unpopular. This is actually a good example of the court adopting a position where the public disagrees, but staying with that position for decades, the counter-majoritarian argument of the Supreme Court that it is capable of standing up to public pressure. And this case, which of course has been litigated many times since Bakke, still shows that substantial amount of public opposition to race in college admissions, despite the court continuing to reaffirm that there are at least some permissible uses of race.
We turn to partisan gerrymanders.
This is a cause célèbre of the last term, but it's the one that people have the least opinion about. 29% really don't know what to think about this. That's in part because it was a complicated decision in the sense that it said federal courts really can't rule on gerrymanders on a purely partisan basis. But you can see that there's opposition on net to it, but one where people are, excuse me, much less intense in opposition here than they were to the previous 2 cases.
Exclusion of birth control coverage by a private business who objects because of religious reasons.
Right. So here, again, there's a lot of opposition to that decision. You will see that we will ask another couple of things that touch on religion or religious liberty. This is an area of legal dispute that's very interesting and very important right now. And it will hinge in what we see here a little bit on who the public sees as benefiting or not benefiting from the decision. In this case, at least from the public's point of view, restricting this access in healthcare plans is not something the public agrees with.
President Trump's travel ban.
Here, actually a little bit more of a divide. You see that the support is a bit higher than we were seeing, but so is opposition. I think here we did mention President Trump's travel ban. So we provided a strong partisan cue because it did come from President Trump in the White House. And so there's a sharp partisan divide on this.
You mentioned the right to same-sex marriage, constitutional right.
So here you get strong support at 36%, strong opposition 26%. Put those together, 56% support same-sex marriage, marriage equality, 36% opposed, and 9% that said they don't know. That's very close to in line with national polling that simply asks whether you think same-sex marriage should be legal or not, which climbed steadily from the late 1980s and then accelerated in support for marriage equality over the last 10 or 15 years to this point where something in the high 50s or low 60s of support shows up in practically every survey about the question, though we ask specifically about the court decision, not in general.
The right to possess a personal firearm.
Okay. Now, this one we actually, I'm responsible for writing these things, quoted or at least closely paraphrased some of the language that Justice Scalia used in his decision to emphasize that this was a personal right to possess a firearm for personal protection. That was part of the language of the decision. It is quite popular. So 67% support that decision for a personal possession of a firearm. It's opposed by just 24%. But stay tuned, we'll come back to another Second Amendment question a little bit later. But I think this is a good example where a decision that was a long time coming on finding a personal protection in the Second Amendment has broad public support at this point.
Let's take a look at 7 possible cases for the future, Charles, and we'll begin with Roe versus Wade.
So this is a fairly common question. Should the court strike down Roe versus Wade? Okay. 47% opposed to that, another strongly opposed, 14% somewhat opposed. Again, in other national polling on the issue, not connected to the court itself, we see similar kinds of divides of, in the ballpark, 60-30, 60-40 splits on this question. 9% still don't have an opinion on this, which is perhaps interesting.
Allowing the administration to end DACA, the program that lets children who were born in the country illegally not be deported, keep them in the country.
Right. Here there's opposition to that. DACA in other polling is a very, has strong public support. People are very sympathetic to children who were brought to the country illegally, grew up here, and so on. And so the program itself is one that draws a lot of sympathy. Here we avoided using President Trump's name in this question. We simply said the administration to end the DACA program. So we didn't include the more polarizing personalization of it by attaching it to President Trump. You do also, of course, see 37% in the green bars who favor that decision or would favor that decision.
What about businesses that would deny service, for example, to gays because of religious reasons?
Here we come back to religious liberty on the one hand, but gay civil rights on the other. And, well, here's the answer. Most people would oppose denying service to people based on their sexual orientation. And whatever that is, 34% would support such a decision. But here we're facing a trade-off that you see in a couple of questions of positive support for gay rights, marriage equality, and so on. You see it here too. It would be interesting. We picked these cases, I should say, because they resemble cases which are percolating through the courts, or some that are actually on the court's docket this year. But it'll be interesting to watch for religious liberty questions that are framed in somewhat different ways to get that trade-off. We deliberately didn't make up a purely hypothetical to pose most clearly a sympathetic religious claim and a sympathetic group claim, whether it's gays or someone else. So that'll be an interesting thing to follow up on. But at this point, you see the balance is, throughout our questions, quite positive towards gay rights in various ways.
This next question of particular interest to many people in this room are sort of one of the leaders in the voucher program, and this relates to that, and the use of religious schools as part of that program.
That's right. So this is a case that is percolating that deals with whether a state program that provides public aid to private school students may also include students in religious schools without a constitutional violation. Okay, so it's a little complicated, but as we boiled it down, largely to provide public support for students in religious schools, and 53% support that. So this is a case where the majority would support that, 33% would oppose, and again, 14% don't know. So relative support here for a religious advantage, if you want to think of it that way, or at least recognizing religious schools as able to receive public support.
You mentioned the Affordable Care Act earlier, Obamacare.
Nothing's going to happen with that. We'll just skip it. So folks are not in love with Obamacare, but they are not very happy with the idea of overturning it at this point. Obamacare, from the time it was passed until the end of 2016, was seen more unfavorably than favorably. But in 2017, when serious effort was made to repeal it in the Congress, that opinion flipped, so it's now net favorable rather than unfavorable. Here, the idea that the court could overturn the entire act, striking it down, is opposed strongly by 35%, supported by 23%. There's still a partisan divide over this, but the balance of support now has shifted in favor of maintaining the Affordable Care Act rather than striking it down.
Next case would involve a ban on semi-automatic rifles, and the Second Amendment playing a key role here.
We phrased this one, this is more hypothetical, but we wanted a Second Amendment case that would pose the current antipathy to semi-automatic rifles, sometimes called assault weapons, but we call them semi-automatic rifles in this question, and whether the Second Amendment would lead to striking down a ban on those semi-automatic weapons. People were opposed to striking down that ban. Okay? So in other words, they sided with banning the rifles rather than supporting the Second Amendment. But I think this is interesting when you compare it with the question we asked earlier about a personal right to a firearm, which was quite popular. Here, the balance is against the semi-automatic rifles, though, again, pretty substantial, 39% would strike down such a ban. The point I want to make here is that these decisions are not unidimensional. We're not seeing a majority that are for the Second Amendment no matter what, or against the Second Amendment no matter what. We're seeing a variety of responses, and that makes sense if people are not structuring their views of the court and its decisions in ways that are strongly structured by legal considerations or my interest group's interest versus somebody else's. Instead, it's a bit contextual, and the way the public thinks about semi-automatic weapons right now is rather different than the way they think about personal possession of a handgun or a firearm for personal safety or protection.
And the final question is about employment discrimination by sex and who it applies to.
So here we have a case that is pending before the court of whether to extend protections for employment discrimination on the basis of sex to LGBTQ people. And that extension, I think I'm on the wrong slide, am I not? There we go.
Yep.
Boy, I was going to say, oh my God, I'm wrong about that. People are supportive of this extension by a substantial margin. And again, I think this is reflective of the overall positive views of supporting sexual orientation cases in favor of LGBTQ people.
How much do party and ideology affect the way people feel about these cases?
Well, this is the key point. I started over there at the lectern, at the podium a moment ago, more than a moment now, by saying that how do we make sense of these things when we haven't read the decisions, we haven't read the statutes? And, you know, even if we're following the discussion, we get a sort of gist of what's at stake, not the legal details. Well, we do it the same way, maybe to a different degree, but the same way that we understand actions of Congress or the presidency, where we don't know every detail of every committee hearing or how the national security staff interacts with the NSA to reach decisions. We make do, and party and ideology are the primary ways that we make do. So I need to explain this chart a little bit. This is based on a statistical model that predicts whether you support or oppose the decision on the basis of your ideology along the x-axis and your partisanship on the y-axis. If party and ideology have no impact on what you think of these decisions, then you would be right at the middle of the crosshairs here at 0-0. Neither party nor ideology would structure your views on this decision. And then, as you come off to the right, you are finding cases where, on ideological terms, liberals are more supportive and conservatives opposed, and vertically, Democrats are more supportive and Republicans opposed. And that's in these two cases, on same-sex marriage and race and admissions. And then down to the lower left, it's the reverse. Now it's conservatives are more in favor and liberals more opposed, and Republicans more in favor and Democrats more opposed. And so you can see, first of all, that the dots roughly line up on a straight line. Party and ideology both serve to structure our views of these cases. But the cases more towards the middle, which includes the race and admissions and corporate political spending, are both less structured by either party or ideology, though not structured, just less structured, than is the case on same-sex marriage at one extreme and on help. I cannot read that from here. Travel ban, sorry. Okay. I've been saying I need a new prescription for a while. Maybe I should take my own advice. So the travel ban, and that actually makes sense, right? Because that's the one where we mentioned President Trump's name in it. But, I'm so sorry, Mike.
No, go ahead.
Birth control, limiting birth control. So those cases are polarizing in both party and ideological terms and are understood in those terms, and then with less of that structuring towards the middle. Now, those were the past cases. Here are the potential future cases. And you see something of the same structuring. Extending sex discrimination is especially strong on ideological terms. Liberals more in favor, conservatives more opposed. But it's actually not very high on party. So party's not structuring that so much, but ideology certainly is. The other cases move in the other direction, with conservatives in support, liberals opposed, and all of them also show a partisan component. But they divide a bit in terms of how strong party and ideology structure those things. So the big point of this, both of these slides, is you would be forgiven if you'd read too much of the political science literature, though you might need a diagnosis for why you did that. But you would be forgiven if you believed that the public is so innocent of knowledge of the court that their responses to questions about cases like this are essentially top-of-the-head phenomena, things people just sort of make up to answer the question and move on. And they're not rooted in anything. And we see plenty of evidence in our survey that people are not deeply knowledgeable about the court. But despite that, party and ideology, the things people use to orient themselves in their other political life, also serves to orient them in the cases that we asked about, the 14 cases we asked about. Almost without exception, though some of those cases are more weakly structured than others. So the upshot is people are making sense of the court in the terminology, the language that they're used to.
We have a few questions. I'm going to let you walk through these fairly quickly, Charles, beginning with the knowledge of the justices and then the knowledge of the authority that the court has. So we'll start with the justices.
So we'll start off with, who are these people? And for a lot of them, it's just a head-scratcher for the public. Justice Breyer has the distinction of being the least well-known justice. I think I have the full question at the top. We wanted to invite people to feel comfortable in telling us they didn't know these folks. So we asked them, have you never heard of them? Have you heard but don't know enough to have an opinion? And if you do have an opinion, is it a favorable or an unfavorable view? So 84% said they either hadn't heard of at all or didn't know enough about Justice Breyer to have an opinion. At the opposite extreme, Justices Kavanaugh and Ginsburg are virtually tied there. There's actually rounding differences that makes one of these 41 and the other 42. So they're essentially equal in public visibility, though perhaps if you think of how visible both of them have been, and because of Kavanaugh's confirmation hearings and practically everything about Justice Ginsburg and her movie career, you would think that more than 41%, or fewer than 41% would say, no, I really don't have any idea about these folks. So I think that's a realistic view. When we ask about your U.S. senator, here in Wisconsin, one of our U.S. senators gets 24% that say they don't know enough to have an opinion about him. So even elected officials often have pretty high rates of unfamiliarity. But with the court, that's especially strong. You'll also see, if you go through these, that all except Justice Kavanaugh have a net favorable view, though the size of that net favorability varies a bit. It will be interesting to watch with Justice Kavanaugh over time as his confirmation hearings moves into the background and his career as a justice begins to dominate, how those views start to change. But as the latest, newest justice and the controversy surrounding his confirmation, you would expect to see high visibility and high polarization, and in effect, that's what you see. Then this is the same kind of plot as you saw for the cases, predicting that favorable or unfavorable view of the justices from ideology and party. And you see that Ginsburg, Sotomayor, and Kagan all cluster together with high party effects and high ideological effects. Justice Breyer is towards the middle. He has a kind of minimal party effect and ideology are both fairly small for him. Justice Roberts is in many ways the most interesting. If he is the swing justice, he's also sort of the median justice in familiarity and recognition, and party plays almost no role whatsoever in how people perceive him in favorable or unfavorable terms, though ideology does structure that some, with conservatives more favorable, but not nearly so much as for the other four justices, with Justice Alito, Thomas, and Gorsuch here in kind of a cluster. And again, Kavanaugh stands out, no doubt because of the recent hearings and the strong battle over his confirmation. So again, party and ideology structured the views of these folks, even though lots of folks can't say they have much of an opinion, in the aggregate, people do make sense of the justices in ways that line up with a conventional view of whether they are more liberal or more conservative. But 28% were unable to recognize a single justice. Another 11% only one. At the opposite end, 8% could name or could react to all 9. If we just collapse that a little bit, 39% could respond, had an opinion of 0 or 1. 27% a minority, 2 to 4. And then finally, 35% actually did have an opinion of a majority of the justices. So call it a third, a third, a third, between very low levels of knowledge and quite high.
Next series of questions are about the authority of the court, people's understanding of that.
So these are some of the questions I mentioned earlier about judicial review. Does the court have the power to strike down acts of Congress that it finds unconstitutional? Overwhelmingly, yeah. So that lesson has stuck with people from 9th grade civics. I got to tell you that when old folks tend to fall down on this, I think it's being far away from formal education. What about if the court rules against the president? Does the president have to obey the court or not obey the court? Though nearly 1 in 4 say the president can ignore decisions of the court. Should something like that happen, that, of course, is a fundamental challenge to legitimacy, so it's interesting. But what about the Bill of Rights? I know it's in here somewhere, but I keep looking for it. So just over half can say it's the first 10 amendments. I kind of like that Article 1 is so popular. But a third, frankly, admit that, no, I don't know which of these it is. We might have delved into what is the Bill of Rights, but we did not. And then finally, and this I do think is so critical, who controls a majority of the court in party of the appointing president terms? First of all, there's a lot of uncertainty. 4% are sure that Democrats control the majority. 19 are sure that Republicans do. But that leaves an awful lot of people in these two middle categories that think it's erroneously probably the Democrats at a quarter, or probably the Republicans at half. So the point here is the partisan branding of the court, despite all the political debate of recent years, is imperfect. If we asked which party has the majority of the U.S. Senate, we would get much more clarity on that question. There's still some folks that don't know. Where am I, Mike?
You have the number of correct factual answers.
Oh, so if you just add these up, how many were right? 29% got all 4 questions right. 4 out of 4, that's an A. 3 out of 4 got, sorry, let's say that right. 39% got 3 out of 4 right. That's a gentleman's C at 75. And then we have some students that may need a little bit of help in the lower levels. But again, combine those, it's not quite a third, but it does show that enormous levels of knowledge are the wrong thing to assume. On the other hand, the idea that nobody knows anything is also wrong.
These are some questions about what motivates the justices.
Yeah, and there's so much talk about political basis of decisions. It's interesting that we find a solid majority who say decisions are motivated primarily by the law. We also asked how should justices or the court understand the law as something where the original meaning is the core or an evolving meaning. Majority picks the evolving meaning. This, of course, is a huge dispute in legal circles, and if we probed about what the public means by these things, we might find that it's limited. Lay notions about what a good judge is. Should it be something that leads to a fair outcome or follows the law even if it produces some unfairness? folks lean towards being fair, that sort of simple lay notion. We see that repeated in some other examples as well. How about empathy? This was something that Justice Sotomayor mentioned in her confirmation hearings. People are very positive towards empathy on the part of a judge. What about wisdom in the application of the law? Lots of support for that. But when we get to following precedent, something that figured in recent hearings, confirmation hearings, it's more divided. People want to follow precedent, but it's not nearly as strong an element in the public mind. And then finally, when we follow a judicial philosophy, people are not overly animated by that. So here you see the difference between what professionals in the legal community may spend a lot of time concerned about the precepts and methods of analysis, whereas the public, in a lay kind of notion, wants fair and wise outcomes that is oddly a little willing to say, you don't have to follow the letter of the law.
We're going to end, and we're running over by a couple of minutes. We're ending with a couple of questions about President Trump, and there's a reason for that.
Right. So this first, how much do you approve of the way Trump is handling his overall job? This was done the beginning of September, 40% approved to some degree, 60% disapproved. Gallup was at 39 at this point, so we were very close to where Gallup was at that moment in time. But what about approval of his handling of Supreme Court nominations? Here, there's not a lot of difference, but look at the extreme. Strongly disapprove overall was 46 disapprove. It's 38 disapprove on the court nominations, and at the other end, strongly approve 20 overall, 22 on nominations. On balance, people are a bit more positive about the nominations, but unsurprisingly, they don't completely flip. Confidence in his next appointment, if he makes one, not surprisingly, largely follows whether you support or oppose the president. I don't think any of you will be shocked by this. And you'll be totally stunned that there's a strong partisan gradient in these views. So much, so good. But what the conclusion is, and oddly enough, we don't have a slide for this last one, but much of the discussion of President Trump and the judiciary has focused on the question of whether you support his judicial nominations and how important those nominations are to one set of people in a positive direction and how important they are in a negative direction for another set of people. A very strong partisan divide on this. But the claim that that is a powerful component of the president's electoral appeal, is that in fact true? So we asked in the survey, would you vote for Trump or Biden? And then we asked, would you vote for Trump or Elizabeth Warren? And then we did a model, created a model predicting that vote choice. For either of them, the results are the same regardless of which Democrat. You will not be shocked that party and ideology and some demographic factors all play a big role in the choice between the two. But in addition, even after controlling for party and ideology and demographics, approval of his court nominations has a significant, statistically significant effect, and the views of Justice Kavanaugh has a statistically significant effect. The views of Gorsuch do not. And so in a fairly hard trial put up against party and ideology in a developing presidential campaign, we do find some support that the judicial actions of the president in nominations do seem to have discernible effects over and beyond the normal political things. Now, they're modest in comparison to the other political things, but they are not non-existent. And so I think we show that there actually are effects of his judicial appointments on his standing with the electorate.
We are going to begin the next panel at 10:10, so you'll have about 15 minutes, not quite 20, but 15 minutes, and then we ask that you be back in your seats. Before we take the break, I'd just like to say thanks to Charles for a terrific presentation. Thank you, Charles.
We will get started again. Thank you for getting back promptly on time. We do appreciate that. My name is Chad Oldfather. I am a member of the faculty here at the law school. Among other things, I teach a variety of constitutional law courses. My main area of scholarly focus is on judicial behavior and the design of judicial institutions and processes. So this is, of course, all very fascinating for me. So we have this information, which we've just heard about, which is, of course, interesting and important in its own right. And what we're going to do now is turn to the task of contextualizing it and attempting to figure out what to do with it, which, of course, raises two distinct sorts of questions, one of which we can characterize as the descriptive questions. How does this information help us to understand how the Supreme Court actually works? And the second set is what we law professors at least phrase as the normative questions. What, if anything, does it tell us about how the Supreme Court ought to work? I suspect that we'll hear a little bit about each in the discussions that follow. What I'm going to do next is introduce our two panelists for this first session, Perspectives from the Academy. I will not spend a great deal of time on introductions because we are here to hear from them rather than to hear me talk about them. But I do want to say a few things. So first we'll hear from Professor Lawrence Baum. He is Professor Emeritus of Political Science at what I understand is referred to as the Ohio State University. Wow.
I should just add, OSU just lost a ruling on getting a trademark for the.
He has spent some time in Madison, so perhaps you'll welcome him a little bit more warmly after knowing that. The primary focus of his work over the course of his career has been judicial behavior, and it has been work that has influenced me greatly. And most recently, he co-authored a book called The Company They Keep, How Partisan Divisions Came to the Supreme Court, which I think is one of the more important books about the court to come out in recent years, and which I believe will form a basis for some of what he's about to tell us. Next, we'll hear from Professor Tara Grove, who is the Mills E. Godwin Jr. Professor of Law and Cabell Research Professor at William & Mary Law School. Her scholarship focuses on constitutional law and the federal judiciary. She is the author of a long list of works that have appeared in impressive places, including among the most recent an essay, a copy of which I believe you received, called The Supreme Court's Legitimacy Dilemma, which appeared in the Harvard Law Review earlier this year. That is not a call to read it at this time. They're each going to speak for approximately 12 minutes, and then I will briefly invite them to respond to one another. Following that, I may have a question or two for them, and then if we have time, we may invite questions from the audience. With that, I will turn it over to Professor Baum.
The survey that Charles conducted and that he's presented this morning is an enormous accomplishment. It is the deepest and broadest analysis of public opinion on the Supreme Court than anyone has done. And that's of great value simply for our understanding of the Supreme Court and its relationship to the public. It's important for a more specific reason as well. And that reason derives from the fact that the Supreme Court, as is often noted, has very little concrete power. And so there's a widespread belief, really a consensus, that the court has to have legitimacy with the general public. If it's not viewed as legitimate, if its role is not viewed as legitimate, then people won't comply with its decisions, and there will be no protection for the court against negative actions by the other branches of government. A fair amount of work has been done through public opinion surveys to try to ascertain whether the court is in danger. Is its legitimacy fragile? And different results from different surveys have different implications. It seems to me, for the most part, that what the public tells us in surveys suggests the court is not in any particular danger. That there's a fairly deep reservoir of support for the court that stands up even during times we might expect the court to be fragile. That's my reading of the survey that Charles has done, though you can make that judgment as well as I can, because you've seen the same results. But as I look at that set of results, it seems to me the justices should feel fairly secure about their position. I want to focus on the question of whether the justices actually act on a feeling of insecurity. In other words, to what extent do justices actually change their behavior, cast different votes, write different opinions from what they would do if they weren't worried about the public? Now, the place to begin, I think, is what the justices themselves say. And it's interesting that the justices often talk about their legitimacy and concerns about their legitimacy. Sometimes they do in their opinions in cases. Maybe most prominently the plurality opinion in the 1992 decision where the court decided to basically uphold Roe versus Wade. More often, the justices in their public statements, in speeches, talks, interviews, refer to the fact that we have to worry about our legitimacy. And not surprisingly, those kinds of statements by the justices have been especially common in the last few years. And I think that's in part because the court has directly and indirectly been involved in major public controversies. And also there is the simple fact that in the last 9 years, for the first time in its history, the court's ideological lines have coincided with partisan lines. Every Democratic justice more liberal than every Republican justice. And I think the justices probably have some fear that what people might in the past have simply perceived as ideological action, now viewed as acting on a partisan basis. So it's not surprising that the justices should be thinking more about their legitimacy and talking more about their legitimacy than they did in the past. That doesn't necessarily mean that they're acting on their concern about legitimacy. And so, as I said a few minutes ago, the question for me is, to what extent do justices actually change their behavior, what they decide in cases, based on a concern about maintaining the support of the general public? I have to say at the outset, I'm skeptical of that idea. And I'm skeptical for two reasons. First, it's a big step for justices to cast votes or to write opinions that depart from their conceptions of what is good law or good policy in the interest of protecting their legitimacy. So let's suppose you're a justice deciding a particular case, and you say, well, I'd like to decide X, but I better decide Y because I need to protect our image with the public. Well, that's giving up something direct, immediate, and concrete for the vague possibility that that's going to have an effect on something you worry about in the longer run. People don't generally do that kind of thing, and I think there's reason to doubt that the justices do. I have a second and more fundamental reason for skepticism, which is that I think that as the justices look at the world outside the court, they are focusing much less on the public at large than they are at segments of elite groups in society that are particularly relevant to them because they are part of their social identity or because they are important audiences for the court. Friends and acquaintances, legal academics, partisan and ideological groups with which justices identify, news media that cover the Supreme Court. Now, even if my skepticism is justified, that doesn't mean the justices pay no attention to the general public, but it does give me reason to really want evidence that they do pay attention to the public. So let's suppose the justices did, in fact, want to respond to the public in order to maintain their legitimacy. What form would their response take? Well, some scholars have argued that the justices try to keep in step with the public ideologically. If the public becomes more liberal, then the justices become more liberal in their decisions. In fact, a number of political scientists have done studies to try to get at that possibility. The best thing to say about the studies is they're inconclusive. This is a hard thing to get at, and they haven't given us a very clear answer. To me, though, it's pretty far-fetched to imagine the justices systematically respond to the public in ideological terms. So a justice might say, well, I've counted up and I voted liberal 55% of the time last term, but the public's moved a little further to the left. Let me do 60% this term. Now, maybe it happens unconsciously. I just find that hard to believe. Now, another possibility gets more attention, and I think deservedly gets more attention. This is that the justices respond selectively to their perceptions of the public. That maybe in the great majority of cases, their perception of public opinion doesn't matter. But there are those occasional cases in which they perceive that the public is strongly on one side. They feel like, well, maybe we shouldn't take a position that runs so counter to the views of the public, because ultimately doing that kind of thing might erode our legitimacy. Now, even that seems to me to be somewhat unlikely. The cases that the public cares about a lot are also cases the justices care about a lot. And to go a direction they don't want to go because they worry about public disapproval, I don't think that's going to happen most of the time. If you have a justice who strongly feels that Roe versus Wade was wrongly decided, will that justice vote to uphold Roe versus Wade because Charles has shown that that's where the public majority resides? They say, not impossible, but seems quite unlikely to me. Now, that's not to say that the justices, under rare circumstances, might take public opinion into account in one way or another. And certainly historically, we can find instances where that may have been the case. But you can also find lots of situations in which the justices took positions that they knew were unpopular and nonetheless maintained it. When the court decided in 1989 that flag burning was protected by the Constitution, that was one of the least popular decisions in the court's history. 1 year later, because of new legislation, the court had to face essentially the same question, and the 5 justices who took the unpopular position in 1989 adhered to that position in 1990. And that seems to me, in observing the court's history, to be the most common thing that justices do. What are the conditions under which justices might, in fact, be most willing to take public opinion into account? Well, first of all, it ought to be a period of time in which there's some reason to think that the court's legitimacy is at stake. And whether or not they're accurate, some justices today seem to have that feeling. Well, you probably want an ideologically divided court, so that if even one justice wanted to take public opinion into account, that justice might determine the court's decision. Maybe that justice stands in the ideological center of the court, so they'd be in a particularly good position to determine what the court does. Maybe the justice has a special concern with the public image of the court, as a Chief Justice might. So, in fact, we are in a time where it seems to me a little more plausible than it usually is that at least one justice is willing to respond to public opinion. And as you're well aware, there's at least a widespread perception, correctly or incorrectly, that Chief Justice Roberts has done that twice. First, in his decisive vote to uphold the Affordable Care Act, or more specifically, the individual mandate in 2012, and second, his decisive vote in the census case on the inclusion of a citizenship question last June. It's not unimaginable that Chief Justice Roberts might in fact prevent the court from overturning Roe versus Wade directly because of a concern similar to the concerns that may in fact have motivated him in those other cases. If people's perceptions of what's happened in the two prior cases are true, if something like that happens in Roe versus Wade, that's not a trivial matter. These are three decisions of great importance. But first of all, we don't know that's what happened or what will happen. And secondly, even if it's true of these three cases, that is a very, very small portion of what the court does. And so my view is, even if the justices say they worry about their legitimacy, and I think they honestly do, when it actually comes down to decision making, this is not something that has much, if any, effect on the decisions they actually reach. Whether that's a good or a bad thing is something Tara's going to talk about. But simply in terms of what actually happens, my view is it doesn't happen much, if at all.
So thanks very much for having me here. I'm delighted to be in Milwaukee for the first time ever. For me, the most striking number in Professor Franklin's survey was that 43% of Americans now favor or strongly favor packing the United States Supreme Court. I cannot emphasize enough what a sea change that is in the way that people think about court packing. I've done a lot of research into the history of court curbing attempts. And one thing that is very clear from at least the 1950s up through early 2018 is that the one court curbing measure that was totally off the table, nobody would ever think about it, was packing the Supreme Court. When court packing was mentioned by political actors, it was mentioned as a political epithet, something that you do not do. But that started to change in fall of 2018. And now, court packing is on the table for 43% of Americans. Now, that suggests some not so good things for what many of us call the Supreme Court's sociological legitimacy. And this is what Professor Baum was just alluding to. Sociological legitimacy is what the public, or maybe part of the public, maybe the elites, think of the Supreme Court at a given time. And I'm going to tell you why Professor Franklin's study is so important for those of us who think about the law and legal reasoning all the time. Because without sociological legitimacy, the Supreme Court can't do much of what it does. The Supreme Court doesn't have an army, it can't enforce its decisions itself. So it has to rely on respect for its decisions in order for it to function. It needs people to believe that it should be an authoritative decision maker. And most importantly, the Supreme Court needs those who disagree with its decisions to be an authoritative decision maker. Think Al Gore complied with Bush versus Gore even though he disagreed with it. George W. Bush complied with the Guantanamo Bay decisions even though he strongly disagreed with them. President Trump has complied with lots and lots of lower court decisions, even as he calls judges so-called judges and derides their opinions as ridiculous. In our society so far, losers view the Supreme Court as a legitimate source of authority, and that's what allows the Supreme Court to function. Now, looking at this study, one might think the Supreme Court's sociological legitimacy looks pretty good right now. A majority of Americans have confidence in the court. But let's think about where that comes from. There's a good deal of political science research that suggests the Supreme Court gets support from a broad array of people because its decisions have been all over the map on the ideologically charged issues that broad numbers of Americans care deeply about. So with swing justices like Justices O'Connor and Kennedy, the Supreme Court issued decisions that were pleasing to progressives on issues like same-sex marriage and affirmative action in university admissions. The Supreme Court also issued decisions that were very pleasing to many conservatives on things like campaign finance and gun rights. And the Supreme Court's decisions on the right to terminate a pregnancy have been literally all over the map, a little bit to each side. And there's a fair amount of political science research that suggests nobody's been the loser across the board. But what happens to the Supreme Court's sociological legitimacy when one group, if this happens, becomes the consistent loser in the most high-profile Supreme Court decisions? I think that is what people are concerned about today. And just as a little thought experiment, and I'm not going to ask for a show of hands, but ask yourself, right now, do you support packing the United States Supreme Court? And then ask yourself, imagine that President Trump gets to replace either Ruth Bader Ginsburg or Stephen Breyer, gets a third justice on the Supreme Court. Then, do you support packing the Supreme Court? So this is the concern that I think the Supreme Court faces right now, the concern to sociological legitimacy, that its decisions might go in one direction and one direction only, and the losers will no longer have an incentive to treat the Supreme Court as legitimate. So what might happen? Well, one possibility is that if a single political party takes over in 2021, is that there would actually be court packing. But what I'm going to suggest to you is it would not stop there. Because once that becomes an accessible form of changing Supreme Court decisions, it's likely that the next political party would also change the number of the Supreme Court justices. We go from 9 to 12 to 16 and so on. So that's not a pretty picture for the Supreme Court. And ask yourselves then, what would losers think of the sociological legitimacy of the packed Supreme Court? So that's one scenario. Another scenario is that the Supreme Court will not want that to happen. And so members of the Supreme Court are going to try to modify their jurisprudence, change their votes, and this is what Professor Baum was alluding to, in order to placate the public. One possibility is just overt switches. So when President Franklin Roosevelt proposed the court packing plan in 1937, many people believe, although this is widely disputed, many people believe that the Supreme Court started to move its jurisprudence and uphold New Deal programs in order to placate President Roosevelt. This is famously called the switch in time that saved 9. During the Civil Rights era, after Brown versus the Board of Education, there was a tremendous pressure on the U.S. Supreme Court. And the U.S. Supreme Court, many people believe, bowed to that public pressure when it refused the NAACP's request. The NAACP implored the Supreme Court, set a deadline on desegregation. That's the only way it's going to be done. Make sure it happens by September 1956. Instead, the justices said, all deliberate speed. The justices even declined to take a case involving interracial marriage in 1955 out of fear of what the public would do if they struck down bans on interracial marriage. In a case called Name versus Name, where one of the people in the couple would be subject to deportation if the marriage was, as it was under Virginia law at the time, invalid. Many people also believe that Chief Justice Roberts, as Professor Baum suggested, switched in the Affordable Care Act case and recently in the census case. So that's a possibility. A third possibility is that the Supreme Court simply does nothing at all. The Supreme Court stays where it is and issues very, very discretionary standards. One can see this in the context of abortion, where this court moved from the very rigid trimester framework of Roe versus Wade to the undue burden standard in Planned Parenthood versus Casey. In the affirmative action context, the standards are also very discretionary. So one possibility is that the Supreme Court will just, for example, in the context of abortion, not overturn Roe versus Wade because of fear of politics, which would dissatisfy many people in the country, but rather declare nothing to be an undue burden. And then everything falls to the lower courts. And what I want to suggest to you is that's not that great for the judiciary either. Ask yourselves, why are lower court confirmation proceedings becoming so partisan? Well, it's probably in part because the lower courts are so important on these high-profile issues that many people care about so much. Now, lower court judges do not decide cases on an ideological basis most of the time, but many political scientists argue, and many senators and presidents believe, that lower court judges are motivated by ideology on some of the high-profile issues, like affirmative action, like abortion, like guns. And so the stakes of lower court appointments go way up. What I want to suggest to you is that none of these scenarios is particularly good for the Supreme Court. None of these scenarios is particularly good for the federal judiciary as a whole. And so then we come back to that 43% number, a number that I suspect would go up with changes in the Supreme Court. 43% for court packing. One of the things I frequently hear from people that do support court packing right now is this is a way to save the Supreme Court. We've got to restructure the Supreme Court to save it from partisanship. Ask yourselves, how would the losers in subsequent Supreme Court cases view a packed court? I want to suggest to you that efforts to save the Supreme Court by structurally reforming it are most likely to do the very opposite.
Thank you both. At this point, if you have anything to say in response to one another, I would invite you to offer some brief reactions.
Well, the one thing I would say is that I think Professor Grove has made a very good argument that's pretty much the opposite of mine. And it really shows, I think, how the history can be understood in different ways. And I'm very glad that you got kind of both sides of that issue.
Well, I actually think we're reading the history in similar ways, but we're emphasizing different parts of it. I think it is true that over the broad majority of cases, the Supreme Court is completely unaffected by public pressure. I also think it's true that for the broad number of Supreme Court justices, they are unaffected by public pressure, even in high-profile cases. But the trick is that you've got to have 5 justices for a majority. And over the course of our history, there's often been 1 or 2 members of the court who are seen as more in the center, and I think in part because of their role in the center, become more concerned about that public perception.
One a topic I'd like to explore that I think is teased a little bit by the poll results. In particular, I'm talking now about the portion of the results that asked the public for its knowledge of individual justices. And it was no surprise to me that Justice Ginsburg was the most widely known. And what that relates to is a phenomenon that some legal scholars have noticed and remarked, I would say generally unfavorably upon over the last several years, which is the notion of the celebrity justice, right? That we have now this world in which Justice Ginsburg has somehow become the notorious RBG. We live in this world in which, and this was a truly striking thing for me. I was at a bookstore in La Crosse, Wisconsin at the beginning of the summer and went to check out. And there at the point of purchase is a little book that I don't remember the exact title, but the notion is it's Wisdom from RBG, right? It's one of these little books that you buy. It's each page is a quote from one of her opinions or speeches or whatever, and that seems to me and to other folks to be a new development, and one that isn't necessarily a good development, because one of the concerns is that if one becomes the notorious RBG and finds that one really likes being the notorious RBG, then suddenly there's a role to be played. There's an audience there, and I think it's a little bit distinct from the focus on elites, because now I'm cultivating a more general image that I may feel, probably unconsciously, but maybe not, I have to behave in a certain way in order to protect and maybe even enhance that. What are your reactions to that, and do you share these concerns?
You want to go first?
This idea of celebrity justice is fascinating, and you're absolutely right. This has become a very interesting phenomenon. I want to distinguish between two kinds of celebrity justices. You quite rightly speak of Justice Ginsburg's celebrity, and I still think it's mostly among people who we would consider elite, but certainly broader than that, is based on the position she takes in the court. And I think you're quite right to say this may exert a subtle pressure on her to maintain the kind of stance that these folks approve of. Justice Sotomayor has sought to be a celebrity too, but not in a way that really has anything to do with what she does as a justice. I don't think, well, I have to confess, my favorite justice is Justice Souter, who never said anything to anybody and wanted nobody to recognize him. So in that small sense, I guess I'm a little disturbed by both the Sotomayor approach and the Ginsburg approach, but much less by the Sotomayor approach. Because I don't think she would ever have much reason to say, if I decide a case this way, it's going to hurt my popularity with my fans, because that's not where the popularity comes from. For Ginsburg, I think it is conceivably a problem.
I agree. And I also think Justice Sotomayor has gone out of her way to reach people who don't normally think about the Supreme Court, including on Sesame Street. So my kids have enjoyed that. And I enjoy saying, hey, there's a justice of the Supreme Court. There's something relevant to what mommy does for a living. And I think that's powerful. And in fact, a scholar has called Justice Sotomayor the people's justice for that reason. With respect to Justice Ginsburg, I have very mixed emotions. It's hard for me to imagine that it's healthy for any one person to be going out and getting that kind of fame. On the other hand, I wonder, should we really judge? Because if any one of us were in our 80s and we could fill an entire football stadium with people because of what we had done in the law, and I think it's not just about her Supreme Court decisions. I think it's about her entire career for the ACLU and the fight for women's rights. I mean, that's pretty cool. And I might prefer that all the justices live in a bubble. I kind of do, and just think deep thoughts. But I think it's hard to begrudge someone for enjoying that in her 80s.
And I will say I'm very much a fan of the Souter model as well. One of my current academic projects has the working title, The Inconspicuous DHS, which, yeah, thank you. I thought it was pretty clever. But certainly that is not, I mean, they're all writing books. Obviously, Justice Breyer didn't get a lot of traction with his. But this does seem to be a thing, and so you know, I think that's something to pay attention to. Another thing I'd be interested in discussing is we've heard talk now about the court's and the justices' own concern for legitimacy, and I wonder, is there a sense in which the rhetoric of legitimacy as used by the justices has shifted? In other words, some people have remarked on the idea that the dissents now seem increasingly likely to take a tone that suggests that what the majority has done is not law-like, is not appropriately legal, which I think is another way of suggesting, perhaps, it's not legitimate. Is that something that you have noticed as well? Does it strike you as a concern?
So I I think the big change in Supreme Court decision making, and it's still a pretty small change, is discussion in court opinions about the Supreme Court's legitimacy at all. This is a really striking feature of Planned Parenthood versus Casey. So the per curiam opinion by O'Connor and Souter and Kennedy, thank you. The per curiam opinion not only reaffirms Roe versus Wade, but modifies it into the undue burden standard, but talks quite a bit about the Supreme Court's public face. And that's something you don't see very often in Supreme Court decisions. And I think it's a big question whether that's a good thing or a bad thing, because the justices, in talking about the Supreme Court's external legitimacy, what I've called its sociological legitimacy, said, this should not influence us, and therefore we have to retain Roe versus Wade. And Justice Scalia said in response, but it is influencing you. Obviously so, you're saying so, and you're saying it's influencing you not to do what, in his view, you believe is right on the law. And that's a big change, and maybe not a healthy one, to the extent the Supreme Court is out there talking about its legitimacy. On the other hand, if they're thinking about it, maybe they should be talking about it.
I have trouble thinking historically about how much has changed and in what ways. And I think you're almost surely right that the justices are speaking more openly about issues of legitimacy than they used to, that it is on their minds. The difficulty, of course, is knowing to what extent that actually influences what they're doing. Did the plurality opinion in Casey, were those justices really influenced by their concern over the court's legitimacy, or is it just one more reason they said, we should do what actually we three really want to do? And I think both are plausible. But it's difficult for me to know when they talk about legitimacy, whether it's in their opinions or in another forum, whether that's actually making a difference in their choices.
In terms of the content of dissents, I don't think that's such a big change over time, personally. Now, dissenting opinions were not that common in the Supreme Court until around the mid-20th century. And then we got into the late 20th century, and then we had all these divided opinions that every student loves to hate, which have part 1 is joined by these 3 people, then part 2B by these 4 people. And these fractured decisions are not good. But in terms of the rhetoric, justices have been telling other justices they're completely wrong for a very long time. And Justice Scalia was of course, the king of this, and in very, very colorful ways. But I feel like a justice saying this decision is completely off the wall, and the majority saying, oh no, we're correct, is a pretty common feature of Supreme Court decisions.
So I think I'll turn there to, and I'm going to talk for a bit and then ask the question, but I'll let you know what the question is going to be, which is what can the justices do? Suppose I'm a justice who is concerned about legitimacy, and I want to act in a way that will help further the court's institutional legitimacy. What do I do? One suggestion that I find intriguing, perhaps even compelling, is something made in an article by Professor Dan Kahan of Yale Law School that was the Supreme Court forward issue in the Harvard Law Review in, I want to say, 2011. And he draws a lot on psychology. And in that particular piece, looking at motivated cognition and its interplay with something called identity protective cognition. And I think about it in terms of a dynamic that seems to me to play out on social media all the time. And it goes a little bit like this. And we'll make it one of your friends, maybe even the crazy uncle that we've all got, shares some meme, or maybe it's an email that aligns perfectly, or so it seems at first glance, with his ideological intuitions. You, who do not share those ideological intuitions, look at it and immediately see all the things that are wrong with it. And the conclusion you draw from it is either he's not very smart, or he's being dishonest. And maybe, I suppose a third version of it is he's just evil. Right? But we easily see the flaws in the other side's thinking. We do not so easily see the flaws in our own, right? Blind spots are called blind spots for a reason, because you don't know they're there, and you can't see what's in them. And what Kahan suggests is that there's a similar dynamic with Supreme Court opinions, right? That I'm going to read one side or the other and agree with it, right? Because it's going to align with my political intuitions, assuming that's what I'm looking for, or perhaps align with my methodological intuitions, whatever. I'll look at the other side, and I will see something that looks to me to be either dishonest or misguided or perhaps even evil. And what Kahan suggests is that a remedy, whether it's on Facebook or in Supreme Court opinions, is for people thinking through these things, people offering justifications, to quite openly acknowledge the fact that these questions are difficult. And he suggests that justices should start writing opinions in ways that don't look like what judicial opinions have always looked like, which is as a lineup of reasons that all uniformly and strongly support toward one, point toward one result. He says that's rarely, if ever, the case. Certainly not the case in situations where there's serious disagreement among members of the Supreme Court. We ought to openly acknowledge that, and thereby enable consumers of these opinions to see the questions as more difficult and subtle than they ought to be. I don't know how realistic that is as something to pull off, but I do find the analysis convincing. Reactions to that, or your own ideas?
Well, I think actually that's an excellent idea, but it runs contrary to the way Supreme Court justices think about what they're doing. Justice Harry Blackmun, when he came on the court, wrote opinions like that. And his colleagues said, no, you didn't do that, Harry. You take a strong stand and you just make your case. And it's interesting that he ran into that negative reaction from his colleagues, because again, I would agree with you that it's common sense. People would react more positively to the court if people did acknowledge that their positions weren't exactly right. But that's hard for people to acknowledge, particularly if they're in a hard-fought battle with their colleagues. And so it's a great prescription, but I can understand why it would be very likely to be adopted by the justices themselves.
I think the difficulty, I think the justices actually do sometimes do this in statutory interpretation cases. They'll say this is a close one. The difficulty in the high-profile cases is if the law is not clear on something like affirmative action or abortion or the Second Amendment, the law really isn't clear, then why is this in the judiciary at all? Why are they deciding this rather than having Congress vote on this or the president issue an order on this? And I think that's the real tension for them, because they need the public to believe that, no, the law is clear in this area, and then when the decisions are split 5-4, it becomes very, very hard for the public to believe. I think there's also a real question, can the justices do anything other than issue opinions? And I think this is a real challenge for the judiciary writ large right now. I've been to a lot of conferences over the past couple of years on judicial independence, sponsored by the federal judiciary, where they say we're worried about our independence, but we'd like the bar to speak out because we can't. And I've been struck over the last couple of weeks, right before the beginning of the Supreme Court's term, that several justices came out and spoke about the U.S. Supreme Court. Roberts, of course, last fall said there are no Obama judges, there are no Trump judges in the federal judiciary, and people questioned whether he should do that. More recently, right before the Supreme Court's term, Chief Justice Roberts went out and said, we are not a political court. We are not partisan. That's not the way we operate. Kagan then came out and said, we are not a political court. We are not partisan. That's not the way we operate. Justice Ginsburg, and this could be a benefit of her fame, she came out and said, court packing is a bad idea. Ending life tenure is a bad idea. And I think there's a real question, is this helpful? Or does it create the sense, methinks thou dost protest too much? I don't know.
Well, I think with that, we've got 5 minutes in which we can take a question or two, or perhaps 3. We've got at least 3, so we'll start right in the middle.
the poll also showed pretty strong support, or showed strong support for term limits.
What would it take to make that happen? Is that a legislative matter or amendment? And then would it have similar pernicious effects for the Supreme Court or the federal judiciary as you think court packing would?
Well, that would require a constitutional amendment. And therefore, the likelihood is 0, I would say, that it would happen. I do want to add one thing, and we may disagree about this. I think that supporting term limits for justices or packing the court doesn't necessarily run contrary to the court's legitimacy. It seems to me that one could support one or both of those steps without feeling like it is saying the court is not a legitimate body. But nonetheless, the fact that there is that much support does raise legitimacy kinds of questions, so I can understand the other side very well.
There are scholars who argue one could limit terms through a statute. By having the Supreme Court sit for 18 years, the justices sit for 18 years on the Supreme Court itself and then go and serve in the lower courts for the remainder of their life tenure. I think that is unconstitutional. The U.S. Constitution, Article 3, says there shall be one Supreme Court, which I think means however many are on that Supreme Court, it has to be the same people. But that proposal is out there. It's gaining some traction not only among scholars, but also political candidates. And I think I would be interested to know, maybe this for a future poll, how many of the people who support term limits would support it only as a constitutional amendment or would support allowing Congress to do it? And I think the answer to that question sends different messages to the U.S. Supreme Court.
And then there's also the question, for which justices would you support term limits?
All right, we'll go. We've got 3 right there, so I'm going to go with the, I'll call it tan blazer. And yes, I forgot to note this. Please press down on the microphone in front of you so that we can.
Thank you. I'm interested in knowing what you think the ideal size of a Supreme Court would be, because it strikes me that every time you talk about changing the size of the Supreme Court, it's immediately attacked as court packing. But it hasn't always been 9. At one point, it got increased. Other courts are different sizes. We now have 11 circuits, and each justice is supposed to be responsible for a circuit, but now we have the numbers don't match anymore. Can we have a discussion about what the appropriate size of a Supreme Court for the 21st century United States of America should be, without descending into political and partisan rhetoric?
So theoretically, yes. And sometimes the size of the Supreme Court has changed for administrative reasons. So back in the 19th century, 18th and 19th century, the Supreme Court did what is called circuit riding. The justices would go out and sit on the lower courts. And at that time, the size of the Supreme Court was largely tied to the number of lower courts that existed and where they existed. So when the Supreme Court was moved from 6 to 7, and then from 7 to 9, it was because of changes in the sizes of circuits. However, there were a couple of moves from 1801 to 1802 and then in the 1860s that were done for largely, if not exclusively, partisan reasons. And of course, 1937 suggestion, that's where we get the term court packing. So yes, we could say there could be a big movement that, hey, the Supreme Court's too small, let's make it bigger so they can hear more cases. We have not had that movement since around the mid-19th century. Since that time when people have wanted to change the size of the Supreme Court, and that this is a new thing since the 1930s, but since that time when people have wanted to change it has been because of the way the court is deciding cases.
I think it's a very interesting question as to whether there's an ideal size. I mean, we could say that most state Supreme Courts have 7 or 9 members. The U.S. Supreme Court has 9 members, so somewhere between 7 and 9 is ideal, but that really wouldn't answer the question. But it's a terrific question. If we thought carefully about what you get and what you lose with larger numbers, maybe we'd get a handle on the answer, but my suspicion is that there's no really good answer to it.
So I actually was on a part of a presentation early in the summer where so they asked me, did you want to participate? I said, sure, it sounds great. It was done for state appellate judges from around the country, and the focus was on various psychological phenomena that affect human and therefore judicial decision-making. And they named the panel for me. And part of my task, unbeknownst to me, until they told me, here's what you're talking about, was to answer that question. And the answer is that you can't answer that in any sort of precise way. Probably an odd number's good. We know that much. And, you know, my sense of why the numbers get larger as one moves up the judicial hierarchy is that it is effectively a matter of, it's a statistical sampling mechanism, right? So that there are areas of law where everyone agrees. There are areas of law, or there are arguments about the law that everyone agrees are off limits. We don't flip coins. We don't do trial by ordeal anymore. And then there's this middle contested ground, right, where there are differences of approach and of opinion that are often ideologically correlated, but not perhaps products of ideology themselves. And I think that the greater numbers are just an effort to reach more often whatever consensus might be said to be there in those areas of contestation. With that, unfortunately, we are out of time. We will reconvene at 11:15 to hear from the bench and bar. All right, we will get started again. I'm reminded of the time I did back-to-back oral arguments before the Minnesota Court of Appeals and began with, may it please the court, my name is still Chad Oldfather. That went about as well as it just did. We are now, as we canvass a variety of perspectives and reactions to the poll, turning to look at it through a different lens, a shift from those whose job it is to observe and comment upon the work of the courts to those who are doing the work that goes on in the courts. My home nowadays is in the former, but I did spend quite a bit of time in the latter. And now and again, still, I do get invited to hang out amongst judges and lawyers. And my sense from a couple recent experiences doing so suggests to me that there is a heightened sense of concern surrounding this sort of broad basket of issues related to judicial legitimacy, and maybe it's more often thought about in terms of judicial independence. I mentioned during the prior panel that I was invited to spend some time with a group of state appellate judges from across the land this summer. And it was put on by an outfit called the National Foundation for Judicial Excellence, which I believe is funded primarily by members of the Civil Defense Bar. And my read of that room, among the judges and the lawyers present alike, was that there was real concern, and there were continuing exhortations made around the importance of an independent judiciary, particularly in a political climate such as the one in which we find ourselves. So I think having this perspective from the trenches, so to speak, is a useful and enlightening one for us to visit as well. Again, I'm going to briefly introduce our participants, and then what we're going to do is hopefully going to look a bit like a seminar discussion rather than a series of lengthy presentations. So here's hoping that goes well. Starting nearest to me and working the way down, we are joined by Peter Keisler, who is currently a co-leader of the Supreme Court an appellate practice group at Sidley Austin. He has, among other things, argued before the Supreme Court as a lawyer, served as a law clerk, first on the D.C. Circuit to Judge Robert Bork, and then on the Supreme Court to Justice Anthony Kennedy, and has served in a number of roles in the Justice Department, including for a time as acting Attorney General of the United States. Next, we have Judge Diane Sykes, who has served as a Wisconsin State Trial Court judge, a Wisconsin Supreme Court justice, and currently sits on the United States Court of Appeals for the Seventh Circuit, and who has for quite some time been a thoughtful contributor on topics such as those we are addressing today, including having served as one of the co-chairs for this summer's, or I guess it was the spring's, Seventh Circuit Bar Association annual meeting, where one of the topics discussed was one very related to what we're talking about today, called the rule of law and judicial independence in a time of political turmoil. And of course, it is important as well to note that she is a Marquette lawyer. Finally, we have Tom Schreiner, a partner at Foley & Lardner here in its Milwaukee office. I could go through a laundry list of the various accolades he has earned over the course of his career, but suffice it to say he is a highly, no doubt among the most, if not the most highly decorated members of the local bar. And as the dean referenced earlier today, he is a longtime member of the adjunct faculty here at the law school. So the plan, again, is for this to be more of a discussion than a series of talks. And what I want to do to kick things off is invite each member of the panel to briefly speak about an aspect of the poll that they found especially interesting or striking, and we will take it from there.
Well, good morning, everyone. I'm really pleased to be here, and I found the entire poll fascinating, and I think it will stand as a very important contribution to the discussion about the court's legitimacy and then the normative questions that arise from that were just explored by our academic panel a few moments ago. And I think the professors helpfully framed the legitimacy discussion around the different dimensions of legitimacy when we're speaking about the court and its work. In particular, the poll took a measure of the court's sociological or social legitimacy, as Professor Grove explained. And that's, in a nutshell, the view that the court is legitimate to the extent that the people, the members of the public, view it as worthy of respect and its decisions as worthy of obedience. There are different dimensions of legitimacy as well that the poll did not measure, and those would include the court's moral legitimacy about whether, as a normative matter, the public ought to obey the court's decisions and treat the court as worthy of respect. And then there's also a legal dimension to legitimacy about the extent to which the court's work and the court itself is staying within accepted legal norms or traditional legal materials in pursuing its work. And I know that Professor Baum has done some work on this area as well. But what we're talking about today is the court's social legitimacy and the extent to which that is important to the court institutionally. I think it's also important to kind of identify the different models of judging that that legal scholars and political science professors have identified, and this is all a vast overgeneralization and an oversimplification, but generally judges can be sorted into those who are mostly motivated by their normative philosophical convictions about what the law ought to be. And then there's another grouping of judges, and these would include those who are more institutionalists, for whom their philosophical commitments are important, but are cabined by the normative constraints that operate on the judiciary, working with text and precedent and the traditional legal materials. And then there are those who are really the legalists, who just are mainly motivated by a desire to get the law right. And so we can kind of group judging into those three different conceptual baskets. And what I found most interesting of the poll, with those background kind of ideas held in mind, was that question about whether the respondents to the poll believed that the court was, or is, as a descriptive matter, again, not a normative matter, but as a descriptive matter, motivated mainly by politics or mainly by law. And I was very gratified to see that a substantial majority of the respondents believe that the court is motivated mainly by the law. That was 64% to 36% rather than politics. So that's, from my standpoint, as a judge, this is my branch of government. I care very deeply about how it performs its role in our system of government and how it's perceived as performing its role in our system of government. That's a good news finding, that the court is perceived as a legal institution, that what it's doing is mostly law and not politics by another means. That percentage went up, and I asked Charles to kind of crunch the numbers for me. That percentage went up the higher the confidence level in the court. So those who said, those who answered the confidence questions about whether they had high trust or confidence in the court and its work, those who said, also answered the mainly the law versus politics question, those who answered mainly the law, that was an 86% to 14% breakdown of those numbers. So that those who held the court in high trust, esteem, and confidence saw it to a greater degree as being mainly a legal institution doing mostly law and not politics by another means. So that's what I found most interesting from my standpoint as a member of this branch of government protecting my institution and its work.
I found those answers similarly heartening. It's good to know that a end of the world you work in has some legitimacy. The U.S. Supreme Court, of course, is not something that figures in my day-to-day practice or that of other lawyers. Unlike the professors who study it, the reporters who report on it, the lower federal court judges who follow it, the world in which Peter and I live involves trying to persuade, in Peter's case, sometimes the Supreme Court, closer to that than I am. I've never had the good or bad luck of having a case to argue in the U.S. Supreme Court. It is, it's a question of what they do, and then we follow it. And it's good to know that what they do is something that is a general proposition the general public accepts as being something that they have confidence in, and that it's being decided based on the law instead of politics. If it were otherwise, I'd still have to react to what they do the same way. But it's better, and it's certainly better for the republic, that the people still have confidence in the Supreme Court. And maybe I'll leave it at that for now.
I too think it was fascinating that you had a 64 to 32 breakdown, people believing the court cares mainly about the law versus mainly about politics. I think the question is, where does that come from? Because it's not intuitive that in a country where there's a whole lot of cynicism about institutions generally and government institutions in particular, and where if you talk about the court, most of the public rhetoric is not defending the court. You have the president speaking often in very political terms about judges and justices. You have a Senate where, roughly half of the Senate will pronounce any nominee unqualified and unsuited for the court. So where do people draw this faith from? Because it's not really in the air around them. And I do wonder whether the current Chief Justice's focus on the legitimacy of the court has been a contributor to that. And if that's so, it's important to think about, well, what is it he actually does? Because historically, Chief Justices don't always care about this. I clerked in 1988 in Justice Kennedy's first term. And, you take advantage of a law clerk for what it's worth. It's a particular perspective. But I don't think Chief Justice Rehnquist thought a second about the external views of the court by the public. He had his ways of being strategic. When he became chief, he subordinated his own individual voice a lot and wrote very differently than when he was a lone associate justice. He would assign opinions, say to Justice O'Connor if there was a fragile majority, because she would adjust her analysis to keep five together, whereas Justice Scalia would just write what he thought. And if it was a plurality, so be it. That's far better. losing a majority than writing something he didn't believe about the methodology of the law. But the Chief Justice then didn't think about how the public thought about the court. The current Chief Justice does, and it's not just a recent thing. I mean, from his first days on that court, he said he wanted the court to function more like a court, not just an aggregation of 9 individuals who vote and reason in a particular way, and then you add them up and see who has the majority. And I agree with Professor Baum. I don't believe, it's not my perception, that he or anyone else has been switching their vote on the outcome of cases in order to protect the court's legitimacy. But there are softer ways for a Chief Justice or other members of the court to try to be stewards of the public perception of the court's neutrality. And they include things like, and the Chief Justice has been very explicit about this, sometimes preferring a narrower 7-2 decision to a bolder and more aggressive 5-4 decision, which requires at least one of the 5 justices who have that bolder view to say, I'm going to step back at this point and not seize the day with this more aggressive theory, because it will be better if there are 7 of us on a narrower rationale. And I agree with the narrower rationale too, so I'm not doing anything that's contrary to my views of the law. There are certainly a lot of cases where the court has just passed on hearing an issue. Think about the long period of time after Justice Scalia's tragic passing, when you had an 8-person court, and how boring the docket was during that time, and how much fewer instances there were in which there were 4-4 decisions by an equally divided court. It was clear that the court during that time, without anyone compromising the integrity of their legal view, they were both passing on some cases and coming together to try to avoid that image of a divided court pivoting on one next member. And you know, look, the Chief Justice's comment about the President's comment about Obama judges, that really put him in a difficult position. Do you engage? Do you not engage? And clearly what he decided to do is, I'm going to make one statement. I'm going to say there are no such things as Obama judges or Trump judges or Bush judges or Clinton judges. There are just judges doing their best to do fair and equal treatment to the people before them. And then he stopped. So he wasn't going to engage on a regular basis. He wasn't going to get drawn into this, but the record was going to be clear that this was his position.
He wasn't going to tweet.
That's I'm sure that was not a difficult decision on his part. But also, you know, he's probably going to be presiding at an impeachment trial in a short amount of time.
First exercise as a trial judge.
Well, yes. And, you know, that can be a very passive role. I mean, the Senate is really in control, and when in the Clinton impeachment trial, that was a passive role. But, boy, it's fraught, and everyone is going to be watching, and I think they will see the court and perceive the court in part through how he conducts himself. And so he's going to have to be thinking, what is the best way to do this fairly and even-handedly and support the public's view of the court, at least, as a neutral institution. I will just make one other sort of preliminary observation about this, which is Larry and Tara talked about Planned Parenthood versus Casey as an example of when, in a case, the court was explicitly talking about the issue of its legitimacy and how it should play in its decision. I'd like to take something that's more recent. It was really striking to me. It was the oral argument in Gill versus Whitford, which was 2017 term of court. And this was a case about partisan gerrymandering, a case that came out of Wisconsin. I don't need to tell a Wisconsin audience about partisan gerrymandering, but just, you know, by way of background, for years the court was in equipoise over whether it could play a role in deciding whether partisan gerrymandering had gone too far and become unconstitutional. Some justices believed it was a natural extension of the one-man, one-vote in racial gerrymandering cases. Others saw no discernible standard in the Constitution for deciding when politics had gone too far in a process that was inherently going to be somewhat political. And you had Justice Kennedy, who said, no one has shown to me a workable test for deciding these cases, but I'm not willing to shut the door that someone might come back to me with a workable test. And so people came back to the court in Gill versus Whitford, case coming out of Wisconsin, with a formula, a mathematical formula with sigmas and epsilons, you know, the essence of neutrality, right? I mean, it mathematical formulas don't know Democrats or Republicans. You just plug in the numbers. And Justice Ginsburg, at one point in the argument, laid out a very kind of fundamental philosophical case for getting involved, the importance of equal votes. And then the Chief Justice asked this question. He said, Mr. Smith, I'm going to follow an example of one of my colleagues, he's referring to Justice Ginsburg, and lay out for you as concisely as I can what is the main problem for me, and give you an opportunity to address it. I would think if the claim is allowed to proceed, there will naturally be a lot of these claims raised around the country. Politics is a very important driving force, and those claims will be raised. And every one of them will come here for a decision on the merits. These cases are not within our discretionary jurisdiction. They're the mandatory jurisdiction. We will have to decide in every case whether the Democrats win or the Republicans win, so it's going to be a problem here across the board. And if you're the intelligent man on the street and the court issues a decision, and let's say, okay, the Democrats win, and that person will say, well, why did the Democrats win? And the answer is going to be because EG was greater than 7%, where EG is the sigma of party X wasted votes minus the sigma of party Y wasted votes over the sigma of party X votes plus party Y votes. And the intelligent man on the street is going to say that's a bunch of baloney. It must be because the Supreme Court preferred the Democrats over the Republicans. And that's going to come out one case after another as these cases are brought in every state. And that is going to cause very serious harm to the status and integrity of the decisions of this court in the eyes of this country. Now, if you take that in isolation, I mean, my first reaction is, surely the court shouldn't be deciding a case in order to avoid public criticism. If in fact this is the right answer, to use this formula, the fact that people will nonetheless think it's partisan can't be a reason for not doing it. That's why we give judges life tenure, so that they can do things in the face of public opposition. But I actually think, and this is why I agree very much with Professor Baum, I think the Chief Justice was really saying he thought it was illegitimate to try to draw this formula from the Constitution. And that if the court did something that illegitimate, in his view, in such a political context, it would just magnify this perception problem. But I don't think anyone who understands the Chief's jurisprudence would think that he would otherwise have wanted to validate this kind of claim. And so the only observation I would make here on this point is that I actually think the court would be better off talking less about its own legitimacy. Because when you ask a question like that, you at least raise the question, gee, is the court actually deciding the case? Because it's concerned about the public perception. And ironically, talking explicitly about your legitimacy may be one of the best ways to undermine it. And the court, I think, is most legitimate when it does what I think the Chief was in fact doing in this case, which is just ruling on the basis of how it sees the law.
So let's go from that to, I guess, taking a more practical question in a way, which is, is there anything in these results that you will take away from here as a practicing lawyer that will affect, however attenuated a way, how you approach the task of making an argument to a court?
No.
Same. I mean, you go where the court is. The court cares about legislative history, talk legislative history. If they care about moral philosophy, talk about moral philosophy. If they care about legitimacy, you talk about legitimacy if they bring it up. But what the polls say.
If they care about mathematical formulas, you learn how to play that game.
Know your audience, it sounds to me.
Well, particularly at the lower court level. I mean, one of the reasons why I was heartened by the result, the confidence that people have in the court, and the Supreme Court we're talking about here, not courts generally, the Supreme Court, the confidence they have and the perception to a statistically very significant degree that court makes its decision based on the law and not politics is, God, it fits with my notion of how this court is supposed to work. And it tells me, at one level, that the guarantees of judicial independence in the Constitution work, and that the people believe they work. The judges who are appointed during their good behavior, as the Constitution says, and without the ability to have their salaries diminished, actually are independent. I mean, I worry a lot more, some of you know some things I've done in the past, about the independence of the judges in the state courts, and particularly the state Supreme Court, because they get elected, and we have campaigns that say, you know, vote against so-and-so because he or she is letting criminals free and that sort of thing. I think that has a much bigger potential, usually resisted, thankfully, to affect the way justices vote than anything that is going on has, including questions about legitimacy in the Supreme Court. The only kind of perception I've ever had that sometimes federal judges are not as independent as they ought to be doesn't come in the Supreme Court. It comes in the lower courts, where some judges are looking for promotion and don't want to annoy the appointing authority, who might move him or her from the district court to the Court of Appeals, or the Court of Appeals to the Supreme Court. That's the leak, but not a big one.
Tom, since you brought up Twitter,
I don't tweet, but I don't even know how to do it.
You brought up Twitter and state Supreme Courts. Just a brief aside, but something, and there's not enough data for this to be anything but anecdata, but it was fascinating to me. Somebody has been carefully observing judges on Twitter, and there are a number of them, and they are mostly state judges, mostly if not exclusively state judges, who have to stand for election. And what this person noticed was of the state judges who were on Twitter, who were then appointed to the federal bench, they stopped tweeting, which isn't really surprising, but suggests something about why they're tweeting.
Different codes of conduct.
Yeah, well, there's
then there's the judge who friended a litigant on his Facebook account and got disqualified in that case. A state court in Wisconsin.
It's a treacherous world out there. Judge Sykes, I'll raise for you a question that got asked during the break, which we heard some speculation in the prior panel about ways in which the justices might change, or the court as a whole might change its behavior in response to perceived threats to its legitimacy. And the question was, suppose that happens in the various ways that it could happen, whether it be that the court stays out of things more, that it is moving more towards balancing tests, I suppose, as opposed to bright line rules. And the question was, what's the implication of that for the lower federal courts? And how does it, if it does, filter down through how judges on the courts of appeals and district courts do their jobs?
I have to first announce disagreement with the premise that the court changes its voting behavior based on concerns about legitimacy. I don't perceive that happens very often, if at all. Every judicial decision begins with the law, but there are prudential considerations that come into play, and in some cases may be decisive. And I can give you lots of examples of that.
When and whether to grant cert, for example.
On cert grants,
right.
Certainly on cert grants, but also in what the ground of decision will be and how it's announced, how it's explained, whether the court will proceed incrementally or from a minimalist impulse, as Peter was describing, or will go maximalist, for lack of a better term. And so those prudential considerations are always operative in every judicial decision, and especially at a court of last resort. I've served on one of those, and I've served on an intermediate court of appeals, and that is a part of the decisional process, as it must be, because there is much gray area in the law. Even so, again, I harken back to the results of this poll. The public does not perceive that as doing politics instead of doing law. The public still perceives that as doing law. And it is incumbent on us, as we explain our decisions, to ground them in the right legal conclusion that flows from the legal materials as applied to the facts of the case, but also to address some of those prudential concerns. The other interesting normative finding in the motivational questions that were asked and methodological questions that Charles asked in this poll was the series of questions about whether the public, after asking the one about law or politics, whether the public sees it as important that the justices are reaching fair decisions and are using empathy, or at least have empathy as a judicial virtue, and whether the court respects precedent, and whether the court reaches a fair decision, even if not quite consistent with the strict application of the law. And it's hard to hold all of those sort of incommensurables in your head at the same time, but they're not necessarily inconsistent, because every judge will endeavor to explain why the right result on the law is also fair, either certainly to the litigants, but also to the other stakeholders and to the public at large and to the rule of law. So even if it seems to produce, if the decision that's dictated by the law seems to produce an unfair outcome to some stakeholder, the court will almost always, at least appellate courts, will take some pains to explain why the decision, which may seem to be unfair in a certain way, actually is fair when all of the relevant considerations are accounted for. But to your point about...
If it's just dead unfair, then it's Congress's fault for passing the law the way
exactly.
it did, right?
That's one standard go-to phrase. But to your point about what the Supreme Court does and what are we to do in the lower courts, we take our cues from what the Supreme Court gives us. And if the Supreme Court is proceeding incrementally or from a minimalist impulse in a certain category of cases, then in our hierarchical system, that's what we in the lower courts do as well. But we do have to decide cases. We don't have a permissive review docket in the Intermediate Court of Appeals. We have to decide everything that comes to us. So we can't duck the hard Second Amendment case or the hard religious liberty case. We need to decide it. And so we do our best to take our cues from the court's decisions as they come to us. The Heller decision is a good example of this. That's the Second Amendment decision in which the court decided the interpretive question, but only the interpretive question about what the Second Amendment means. Is it an individual right to keep and bear arms, or is it a collective right tied to militia service? The court didn't give us any doctrine about how we're to decide follow-on challenges to gun regulations and how to reconcile conflicts between Second Amendment gun rights and the public's right to regulation of dangerous instrumentalities. So the police power of the states and the federal government's power to regulate firearms. And so we in the lower courts have been trying to tease out some doctrine from the Heller decision. In my own case, I've written several decisions on this and saw some First Amendment doctrinal parallels in the Heller decision that we could begin to build on in the lower courts incrementally in developing a doctrine. In the religious liberty area, the court has been proceeding painfully incrementally in Establishment Clause jurisprudence.
Back and forth sometimes.
Back and forth sometimes. Some religious displays will survive because they're historical, and others will be struck down because they violate the dreaded Lemon test.
Right.
But the court hasn't gotten rid of the Lemon test, which is essentially a balancing test for the non-lawyers in the room that looks to the purpose of the religious display as against its effect on the public and tries to strike a balance. And so some religious Christmas symbols will survive and others will not, etc. So that's a very sort of incremental area that the court hasn't given us clear rules, bold rules, bright lines. And so we proceed incrementally as a consequence. So as a lower court, we take our cues.
How can you not, when it's unconstitutional to have the 10 Commandments in the courtroom, but it's constitutional to have it in the yard out in front of the courthouse, according to the Supreme Court.
Yeah. That's holding inconsistent things in your head at the same time.
Right.
Judge Sykes mentions the gun case and the gun cases, and it's interesting because for the first time in I think about 10 years, the court has a gun case on the docket this term. In fact, this term is just like your cornucopia of hot-button issues because you now have guns, abortion, whether Title VII protects gay and transgender employees, the Dreamers. Maybe you'll have a congressional subpoena fight. Maybe you'll have an Affordable Care Act case from the Fifth Circuit. So it's a lot of stressors this term in the middle of an election year as well. And the gun case is interesting because it has turned out to be a focal point for so many of the issues we've been discussing today. And that's because New York law that's at issue in that case has been modified some. And so New York came to the court and said you should dismiss the case as moot. And there's some sense that people on that side of the debate very much don't want the Supreme Court, the current Supreme Court, to say something more about the constitutionality of gun control under the Second Amendment at this point in time. And there was a quite remarkable brief that was filed in support of New York's suggestion of mootness by Senator Sheldon Whitehouse, joined by 4 of his colleagues. And some of you are nodding. You're familiar with this. It's a brief which is very antagonistic in its tone to the court and ends by saying, and this is, I think, close to an exact quote, the court is not well, and the people know it. The court needs to heal itself before it is restructured in order to reduce the influence of politics on it. And it was signed by Senator Whitehouse and 4 of his colleagues. Normally, when members of Congress file amicus briefs in the court, there's a law firm that is representing them as their counsel. No law firm signed this brief. And I think you can imagine why, but you can also imagine that Senator Whitehouse probably wouldn't have wanted that. This was his direct communication to the court. And it's sort of a Rorschach for how people react to things. I mean, some people looked at that and said, you know, it's almost like, nice little court you got there. It'd be a shame if anything were to happen to it. Kind of a threat from the other branch. And that was how 53 Republican senators responded. Because they then wrote a letter to the clerk of the court saying, you know, this is terrible, you're threatening the independence of the judiciary, Senator Whitehouse, and we want the court to know that as long as all 53 of us are here, there will be no court packing, signed by all 53 Republican senators, which I think was probably for the court about as welcome a communication as Senator Whitehouse's, because the last thing they want is to be a prop for these kinds of partisan debates. And I do wonder, particularly with the Senator Whitehouse brief, which is what initiated this, what is the audience for that? I don't think most of the public know the brief was filed, so it's hard to see this as a big public relations thing. But within the court, you know, the 5 justices who I guess he was trying to persuade to change their vote are not going to react positively to that, nor are there 4 colleagues who don't like to see their colleagues disparaged and don't accept this characterization of the court. But it is an example of how these things are just coming to the surface in ways they never used to before.
So that tees up the next question I was going to ask, which is this era, is it really different now? And I'm reminded, and it's not directly on point, but it's close, of Carl Llewellyn in 1960 writes this book called The Common Law Tradition, where he sort of sets out to rehabilitate in some way some of the perceived damage that he and his legal realist colleagues had done to the reputation of the courts, and opens with this description of everyone thinks it's horrible, that courts are lawless, that the world's falling apart. I'm here to tell you that it's not so bad as that. And so, you know, is this something that just comes up from time to time, that always seems like it's the worst crisis just because it's the present crisis, or is this truly different?
Yes, it's something that comes up all the time, and anyone with any appreciation of history of the United States generally, and certainly the history of the courts, would know that there have been horrible times. You know, we talk about court packing in 1937. I always think of the court packing in 1862 when Mr. Lincoln wanted to make sure that paper could be legal tender so that he could finance Civil War, and appointed this war Democrat from California, Stephen J. Field, to the court. Field, by the way, never left. He stayed around for almost 40 years. And in order to do so, Congress increased the size of the Supreme Court to 10. It worked. Legal tender was upheld. Later on, Lincoln got assassinated. This guy Johnson, who should have been convicted when he was impeached, became president. And what did the Supreme Court do? It started abolishing court seats whenever a vacancy occurred. You can't fill that one because it's no longer there. That's how we got to 9, by the way, when he finally left office, and it was safe again to have 9 justices. So, there have been bad times for the court. There have been times when it has been very strongly, vehemently attacked by the political branches. This is one of those. And, one of the heartening things when I get back to the things that hearten me about this poll is that I don't think the people are buying it with respect to the court. And, it's a good thing to have one of the branches of our government be legitimate. Right? Particularly when the other two seem intent on destroying themselves from the point of view of legitimacy.
That's the final word on that.
I guess we're going to leave that there.
You were going to touch it.
Would you have a few minutes to take a question or two? Please.
I'm wondering if we're getting a little more optimistic about the Supreme Court than we should be. It sort of reminds me of asking a survival of a major disaster like a tornado or some of those devastating fires we had in California. And they walk up to the guy and the guy says, "So how do you feel?" I said, "Well, we lost everything, but I'm happy, I'm alive." Right. And then, of course, a month or two later, and nobody hears about it, he commits a suicide. Now, I'm not going to go that dramatic as far as our Supreme Court is concerned, okay? But I'm wondering whether people are questioning what he just ended up with. Is if the other two branches are so pathetically, untrustworthy, what are we going to trust into if not a Supreme Court? So, and sort of on a separate little topic, is when you look at the legitimacy of a particular candidate, okay? When you look for a candidate on a basis of his or her political ideology in the past, and you pick a qualified, otherwise perfectly qualified judge from a group that goes with your specific ideology, and then they get on a court through contributions of people in that ideology, and then they get on a court case where they vote in favor of that ideology. Can you really say that they just decided that on a basis of the merits of the case rather than on a basis of their ideology, or is it on a basis of where the money came from? And does it really make a difference? Because again, they were picked out of a particular basket that favored their ideology. How do you justify legitimacy of the court then?
There are very few presidents who haven't taken into consideration the views of the people they've appointed to the Supreme Court. Ultimately, the reason court packing fizzled out, other than the fact that it was very politically unpopular, is that Roosevelt got to appoint a bunch of people to the court who he was pretty damn sure, and it turned out to be the case, would uphold the actions of Congress of the sort that the prior court hadn't done. So there is a way of resolving it. Presidents have always done, very few, I say very few. Obviously, General Eisenhower didn't really understand either Earl Warren's or William Brennan's views of the Constitution when he appointed them to the Supreme Court of the United States. So, it's a political institution in the sense that that's how you get on that court. We don't have an election as we do in the States, but we have this what's become overly political, brazenly political appointment, followed by the expected attack by almost a majority of the Senate on whoever is being put forward, and then going out to see what you can find out about their past and dragging them through the mud. I mean, it hurts the institution to have that kind of stuff going on. But you can't avoid it because that's one of the protections in the Constitution too, is that you've got to get somebody appointed, and that person has to get a majority of votes in the Senate to become a judge. That isn't going to change, and we've survived that. We've survived that for 230 years, and I don't see any real indication that we're not going to survive it. I wish it weren't so nasty, and maybe at some point these people who like the court, the public, who really want to have a court that is legitimate and that they can continue to support, will say, enough of this, stop it. I have some confidence that can happen. I don't know.
Yeah, and I'd like to resist some aspects of the picture you just painted, because I think the individual elements are, largely accurate. I mean, presidents appoint judges who have a certain philosophy of judging that the president wants to share and promote. There are multi-million-dollar campaigns to support or oppose the confirmation of justices. Those are extremely corrosive. But what do we end up with? Well, we just finished the first term in which Justice Kavanaugh replaced Justice Kennedy. And if you take the subset of 5-4 decisions that you'd consider ideological, in the sense that people are mostly voting according to the patterns that people associate with that way, 56% of them were cases in which Justices Ginsburg, Breyer, Sotomayor, and Kagan were in the majority. So in a majority of them, one of the 5, what we call conservative justices, joined with them to form a majority of those 5-4 cases. You have Justice Gorsuch and Kavanaugh, both conservative, both appointed by the same president, both roughly the same age, both sharing, eerily similar backgrounds going back to overlapping at the same Washington, D.C. high school. They voted together in that term 70% of the time, which may seem like a high number, but 40% of the court's cases were unanimous. They were together only 56% of the time of the 5-4 cases. And that's the lowest rate of agreement of any two nominees in their first year from the same president since President Kennedy put Byron White and Arthur Goldberg on the court. By contrast, Justice Kagan and Justice Sotomayor voted together 96% of the time their first year in the court. And I say this simply to suggest that the situation on the court is more fluid and human and evolving than some of the ingredients into the process would lead you to believe it would turn out to be. So I do think there is reason for hope. I don't think we're a month away from the suicide. I look on it much more favorably, much more optimistically, and that is why I'm with the 64% who say I think they're deciding things on the basis of the law.
Well, that is a very hopeful note to end on, which is good because it's time for us to end. So a couple of administrative notes. We reconvene at 12:30. Meantime, there are boxed lunches outside. There are 2 tables set up. I think leaving from either door will lead you to one. There are vegetarian options as well as non-vegetarian options. And with that, again, 12:30, and please join me in thanking the panel.
All right, welcome back. Good to be with you again. We are going to continue with our final panel of the day, and we are talking with members of the media, getting their reaction to the poll results that have been presented earlier today. Seated next to me is Bob Barnes. He is a longtime reporter and editor for the Washington Post. He has been covering the Supreme Court, the U.S. Supreme Court, for more than a decade now. We welcome Bob to Milwaukee. And seated next to Bob is Carl Holtz. He is the chief Washington correspondent for the New York Times. He's also the author of the new book, or relatively new book, Confirmation Bias, Washington's War Over the Supreme Court, from Scalia's Death to Justice Kavanaugh. So, gentlemen, thanks very much for being here today. And I'll ask you the same question that others have been asked today. Your takeaways from the poll. And, Bob, I'll begin with you. What stood out to you?
Well, first, thanks for having me. It's been an interesting morning. Sorry that this is how it wraps up for you guys, but that's what happens. You knew what you were in for. I think it's interesting that there is this reservoir of goodwill, it seems to me, for the court. I think it's an interesting idea whether it's good that people can't actually identify the individual justices, because it sort of does mean that the court speaks with a voice, whether or not you agree or disagree with it. I am not quite as optimistic as some of the others about whether this is going to continue. I think we have a very, as you heard, divisive term coming up. And, there's this thing called impeachment that's hanging out there. And I think it's inevitable that the court gets pulled into some aspect of that, whether it's on the congressional subpoena power or the state subpoena power in this New York case. It'll be interesting.
Let alone Judge Roberts presiding over this.
Yeah, the Chief Justice being at the forefront of it. But, in past, there have only been a few real precedents about impeachment that the court has done or about this kind of question about presidential power, and they have been unanimous in the past, and it'll be really interesting to see what the court does with that kind of issue when it's faced with it.
Thank you also for having me. I grew up in northern Illinois, so I feel a kinship here. However,
this is a tough room. They booed Ohio State earlier.
I am a Cubs and a Bears fan, so so I invite that. That's good. Let's get that out of the way.
I don't particularly like him either.
It's a deep, widely held opinion. So I have to say, first, a couple things. The majority support for term limits really jumped out at me. That was my big thing when I looked at that. That tells me that the court has a problem, that there's people, a majority of the country looks at that and says, we need to make that significant a change. I think it's due to a lot of things. I think, honestly, I hate to sound ageist sometimes, and we can say this about Congress and particularly the Senate, people really hang around for a long time. So I did think that was interesting. I also thought the court packing answer was informative, and I really can't wait to cover the story about the court challenging the constitutionality of the court packing or term limits cases. That's going to be some big stuff. So I think that I agree 100% with Bob. We've been talking about this, and as someone said earlier, I'm not a lawyer. I don't really even cover the court. I cover politics around the court. And I just think that Justice Roberts and the other justices last year, they managed to sort of diffuse a lot of things, and there was cases that were being put aside. We have this huge lineup of potentially explosive cases coming this year, and not to mention the impeachment. If there's a fight over the subpoenas at the court or over the tax law, which seems to be, the fight over the tax returns, which seems to be moving in that direction, people are going to be looking at the court in terms of how they're deciding and how the Trump appointees are deciding in cases involving the president. So I think you do this poll again. A lot of things could happen. Maybe I'm wrong, and maybe, as I said to Bob earlier, there'll be this great coming together and everything will be okay. But I don't think so. My experience in Washington tells me that's not the case. And, I think the court, because of what's gone on my end of it, the confirmation fights, Merrick Garland, people are just looking at it through a different lens now. And also, one last thing on this, the 5-4 split is really a 5-4 split now. And you can tell and I'm not saying on all the cases, and Bob can talk much more deeply about that, but people just do see the 5 Republican nominees, the 4 Democratic, and though they cross over a little, it's not like when Kennedy was there or even Souter, where there was sort of a middle. I don't think people see that. So I think the court's got some issues and may be able to resolve them. I'm not so sure the nomination process is going to resolve itself anytime soon.
Based on your work covering the court, Bob, how much do you think the justices think about this issue of legitimacy, how they're perceived by the public? How much do they really give that serious thought?
I think they give it serious thought. I agree with someone, and I don't remember who said it earlier, that I don't think it particularly affects the outcome of the cases very much. Maybe it affects the narrowness of the decision, but, you know, I don't think that someone votes one way that they don't really believe in order to make it come out to look like it's not a 5-4, that it's not as you know, divisive as it is. You know, the court also has a lot of discretion about what court cases to take, and I think that a lot of things go on behind the scenes that we never know about, in which they have decided not to take a case for certain reasons. You know, as someone mentioned, it was 10 years from the Heller decision on handguns to the court taking another, and not until Justice Kennedy left the court. I don't think either side of that question, I don't think it's like there was a big agreement on the court. I think that there were two sides, and nobody knew how Kennedy would go if they took one of these cases. And I think Justice Stevens sort of said that in his most recent book before his death. So, you know, I do think that there is a sort of core to the court that wants to make sure the public trusts it.
The Chief Justice foremost
The
among
Chief
those,
Justice thinks it's his responsibility. He often says that he's only the 17th Chief Justice, even though we've had 45 presidents. And I think he feels a huge amount of institutional responsibility.
Yeah, he seems almost pained by the argument over the court's legitimacy in politics, and I think he's trying to do all that he can. And the other justices, certainly Justice Gorsuch, you know, he's got a book out, and I think he talked about, you know, we don't have R's or D's. But I think it's almost impossible to escape. I mean, the gentleman's question from earlier, you know, these people are nominated by presidents of a certain party and, you know, confirmed or not confirmed by the Senate controlled by a certain party. And I just think that people see the politics at work here. I think the court has been very good over decades and decades of avoiding it. We just seem to be, because of the polarized, what I've said in my book, because of the polarized aspects of our politics, the courts and the lower courts, which are even more important in some of this, have become the referees, and people are much more focused now on what the referees are doing.
People in the poll felt that the justices were following the law. That was the motivation rather than politics. They felt they were moderate, perhaps leaning a bit more conservative, but moderate, not politically to the extremes. That's sort of the good news, but there's also in that poll a lot of evidence that people don't really understand the court very much, that they don't know all that much about it. And I want to ask you, as somebody who covers the court on a daily basis, why is that? Is it because of the content of the cases? Is it because that people are not lawyers and it seems more difficult to understand? Why is it?
Well, I'm glad you didn't throw out as a reason because I do a poor job of describing.
Nothing but the best, Bob.
You know, I think these are complicated issues. They are deciding issues of law. They are deciding, and this is one thing that I've come to appreciate about the court since I've been covering it, is that they are sometimes interpreting some really crappy laws that Congress has passed, in which Congress has not wanted to make the tough decisions about how these things will play out. They leave it for judges to sort through it. So, you know, it's a complicated business that they're doing. They also, you know, I think people do grasp the big decisions, but I think people also tend to see them, as the poll pointed out, as to whether they think that was a fair decision or not, whether it's one that they agreed with. And so, you know, it's a little hard. I mean, the justices do say why they're voting this way. It's one of the, you know, few branch. They love to say that they're the most open branch because everything that they base their decisions on are public records, except for a very small part of things that you know, are shielded. Everybody has the same information. when they vote, they have to sign their name to a decision and say why they were on this side or that side, explain the reasoning. No one else has to do that, they like to point out. But it's still a complicated and sort of mysterious branch, partly because they're not on TV. They don't. You can't watch their deliberations. You don't even get to hear them announce their decisions. And so I think there is a sort of mystery there that's hard to cut through.
You were nodding your head in disagreement with the notion that they're more transparent than other branches.
I used to live right behind the Supreme Court, and I always looked at those walls and I go, boy, hard to see through there. That's pretty opaque. And I may be in a minority here on this. I'm for televised coverage of the Supreme Court. I think that would be helpful. A lot of people don't. They think it affects the way people act. I mean, that's exactly what was said about C-SPAN in Congress. I think that's turned out to be pretty good. I think the judges themselves like to cultivate this not knowing because it makes their lives easier as they go around and do things. People don't recognize them, although I think that you're having a difficulty now with Brett Kavanaugh and Ruth Bader Ginsburg. I mean, they're national celebrities. I thought that poor Justice Breyer, I don't know how he would feel about that, because he thinks he's pretty well known. Trust me. So I'm for more. I'm for audio. But I'm a reporter. I'm like, I want everything out there. I'm not saying they need to televise their deliberations, but I think it would be helpful for people if they understood kind of what was going on and watch it. And you know what? They'll watch the big cases. They won't watch the small cases. Bob knows more about this than I do, but they instituted this 2-minute rule this year so they don't leap down the throat of the lawyers who are presenting their cases. I think they each get 2 minutes, and I think because more of this is now coming out on transcript and audio, that they thought that looked bad for them. They were, rude. So, they've been able to function in that beautiful, beautiful building over there, sort of under the cloak of no media, and I think that is part of the reason people don't understand it, but I also think it should be changed.
Does the fact that you feel you can't cover them in the same way you cover some of these other branches of government?
I get to pigeonhole senators in the hallway.
Do you think, in some respects, that allows them to fly above the public contempt we have for some of the other?
Let's be honest. Yeah, the poor Congress. They always come off so bad in those polls. Yeah, I do think, and I think it's helped them. And I actually said this in my book that it has helped them keep us standing above the other branches of government, which has been great. It's upheld their credibility and legitimacy, but I think it's slipping a little bit.
Let's talk for a moment about politics and the court, and I don't know, the potential threat that an increasingly polarized electorate at this moment in our history could pose to the Supreme Court. You look at the numbers in that poll, Bob, could you see erosion of those numbers because of how politicized the confirmation process has become?
Well, yeah, I think you could. I do think that there's, and Charles would know better, I think Gallup, that does an annual poll of the Supreme Court, you'll see that when a Democrat is in the White House, Democrats think better of the Supreme Court because they somehow identify the court with the president. And when the election happens and a Republican is in, then those positions completely switch, and Republicans think better of the court and Democrats don't. So I think that there is that sort of natural ebb a little bit. I think that the confirmation hearings have really gotten to be sort of an awful spectacle because I don't think anyone watching them would think there are some truly undecided senators on the Senate Judiciary Committee and they're just trying to find out if this person is qualified for the Supreme Court or not. And I think that is a big loss. I fear that we've reached the point where a president of one party would not be able to get his or her nominee through a Senate of the other party, no matter who that person is. And I hope I'm wrong about that, because it's not the way the system is supposed to work. But I don't see what's going to really change that.
Could you make the argument, Carl, that the U.S. Senate poses the greatest threat to public confidence in the Supreme Court?
I think I'd hate to say it poses more of a threat than the court itself and how it conducts itself, but I would say it poses a significant threat. And I mean, there's a real possibility that what Bob just said could get tested beginning in 2021. I'd say that right now the Senate Republicans are favored to hold on to the Senate, no matter who wins the presidency. So then what happens if a Democrat's in and trying to fill a vacancy? I just think the entire confirmation process, excuse me, has just become poisonous and broken down. But let's move on to the presidential campaign. Democrats, last week in the debate, how long do those debates go now? They're like 8 hours.
That was at least three that we know of, yeah.
But that was the first time they began to talk seriously about their proposals for term limits or to expand the court. You're going to see this as a continuing argument developing now in the presidential campaign, because Joe Biden and somebody else Elizabeth Warren sort of waffled on it a little bit. Biden said he wouldn't want to add to the court, but other people would definitely want to do something. And Mayor Pete's got this proposal that's, 15 and 5 on each side. I don't even know how that would work. Pick whoever it is. So, that is also going to polarize the court. And I'll tell you, if there is a vacancy during the next year, it's just going to explode everything. I mean, it's going to be incendiary. It's going to spill into the presidential campaign. I also said in my book that one of the worst outcomes of the Kavanaugh fight was that both sides thought they benefited politically. Republicans thought they did well in the Senate because of it. Democrats, they thought. So I said that was the worst possible outcome for fixing the nomination process, when both sides see that they can benefit from these kind of fights. And if you get into one next year, it's just, it will be really a very, very difficult situation.
Yeah, and it'll be interesting to see in this election. The Supreme Court has always been a much more important issue to Republicans in their selection for president than it has been for Democrats. It's always, if you ask an open-ended question of Republicans, the Supreme Court is very high on their list of voting motives and what motivates them. Much further down on the list for Democrats.
Why is it?
I don't know why that is, except that it seems fairly historical. Seems like maybe there's a little bit of the change. A poll that the Post did after the election showed that 25% of Trump voters said that they voted for him because of the Supreme Court. And that's a huge chunk of people to pick one reason why you picked a candidate.
Yeah, I mean, the exit polls, too, from that election show very clearly that conservatives voted for Trump over that vacancy. The vacancy created by Merrick Garland's, by not having a hearing or filling that seat, the vacancy created by Mitch McConnell's stonewalling of Merrick Garland was a huge factor in Donald Trump's election. And he probably wouldn't.
I'm sorry.
Yeah. No, but Democrats are trying to catch up, but they're way behind. I just think that conservative voters see the Supreme Court as kind of this bulwark for the social values that they hold most important, and they've always voted more intently on it. Democrats, and they kind of vote on policy, and we'll get the right people in there. That's just a different thought process. But you do see new groups popping up among Democrats to try and even this up.
What's the legacy of the Merrick Garland case? And by case, I mean the fact that he was nominated, there was no hearing. From your vantage point, what's been the aftermath of the Garland case, which we saw people still feel pretty strongly about in the poll?
Yeah, they do. I don't know if there was a big lesson. If there was, it was that politics is playing a bigger role in Supreme Court appointments than it has in the past. I mean, he was a very well-respected judge. He has a lot of friends on the Supreme Court, including the person who got the job instead of him.
And spoke highly, actually, in this building, spoke highly of Merrick Garland.
Well, it's easy to now, right?
Yeah.
But,
that was before, though. He was. Yeah.
I think he was well respected. I also think there's some truth to the idea that if that opening hadn't come when it did, that Merrick Garland wouldn't have been President Obama's nominee. He would have looked for someone younger, more liberal. I mean, it was a strategic decision that didn't work.
Well, and a lot of people, you talk to Democrats, they think it was the wrong strategic decision, that Obama miscalculated. Orrin Hatch had said good things about Merrick Garland in 2010, so he thought that was going to transfer to 2016, and it didn't. I mean, the legacy of Merrick Garland in terms of the Senate is like huge bitterness among the Democrats. And so you talk to a Democrat about the judicial nomination process, they'll go Merrick Garland. You talk to a Republican, they'll say Robert Bork. So these things stick around forever. I will say about Merrick Garland, who I don't know, but he is, he's so widely admired and well-liked. And one thing, a takeaway from my book that I heard from lawyers was, wow, the more you think about it, that was a terrible way to treat Merrick Garland. And I will say that Merrick Garland is such a fine gentleman that he called me twice to tell me he wouldn't talk to me for my book. So now that's a good guy.
So the contradiction is that the poll says that people do not want nominees rejected because of party politics, policy differences, that if you're qualified, and they should be confirmed. And yet, the Garland case, in your book, Carl, points to this and details it to a great extent. Mitch McConnell, that may be what the public says, but he saw an opportunity and had no qualms about saying, we're not going to move forward with this nomination.
Yeah, no, he had a lot of reasons that he has said he was doing it. This has been the fight, and that I kind of talk about in my book, since 2000. There was this, Chuck Schumer at the time was trying to make the case that it should be okay to vote and review judicial nominees on the basis of their ideology. Schumer's argument was, well, because we don't do it on ideology, we end up, you're opposed to them. You can't say it's publicly, so it's because they went bankrupt or they smoked a joint or whatever, and it became more about their personal failings. And they've never been able to make that leap. I think everybody wants to sit back and say, well, let's just look at these qualified judges and make a decision. But here's what's happened. Between 3 different rules changes on judges since 2013, initiated by Harry Reid, but McConnell has done 2 himself. It used to be, they would always say, well, you don't filibuster judges. But what you did have is the threat of the filibuster. So you needed somewhat of a consensus person, and they would probably, if you go under that rule, they're going to be left of center or right of center, depending on who the president is at that time. Somewhere in there, and somewhere where the people on the poll said that they want nominees to be. But because that filibuster is gone now, there's no threat, all this other technical stuff that I talk about in the book, the blue slip, which I'm sure many people here know about, that's all gone. So it's just one side versus the other now, and there's simple majority vote. And Democrats are already preparing with their own lists of candidates and telling judges not to take senior status until after the election, so they can then do what the Republicans have done to them, is to go line up and push through a bunch of people they think are more in tune with their ideology. So somebody mentioned this earlier today, and this is one of my pet theories about Congress and politics, is that when one side does something to somebody else, as soon as the other side gets a chance, they do the same thing, but a little more. They just turn it a little bit more. Then the next, they get back in, they turn it a little bit more. And we're just in this sort of pattern and trend that is not working well at all.
How much did the end of the filibuster, for instance, contribute to this more political environment for nominees?
Well, I think that it probably means that some people who wouldn't have been nominated in the past have been nominated and confirmed. They didn't have to worry about getting to 60 votes. They could find someone further out on either extreme. I guess we've only had it for one extreme, but I think that that's what it is going to mean. I don't think that that has happened with, for instance, President Trump's two nominees. I think that those were people who would have been nominated by any Republican who was elected president. So I don't think it has had an effect there, but I think it probably has in the lower courts.
I remember back 2005, Russ Feingold was the U.S. Senator, one of our U.S. Senators representing Wisconsin, and John Roberts was the nominee. And I remember Russ Feingold saying, I'm going to vote for John Roberts for confirmation because you can't argue that he's not qualified. And I think a president, I have some respect for the principle of deference to a president. Are those days gone? Are we going to see very many people willing to take that stance in the world we live in today?
Well, Democrats now almost just reflexively vote against every Trump nominee. There's a few. I saw a district judge the other day. That must have been a really non-controversial district judge, got quite a few Democratic votes. So, yeah, I think that's kind of what Bob is talking about. So let's say Mitch McConnell is the majority leader next year, or 2021. Mm-hmm. And President Warren, I'll just throw that out there to see how that sounds, there's a vacancy that occurs. So Mitch McConnell, to his credit, I guess, has already said, well, we wouldn't be able to deny that person a hearing for political reasons. We would have to move ahead with some sort of hearing. It's not going to be like Merrick Garland. But there's no guarantee, he said, that person could get approved. So there's no deference there.
Yeah, I'll disagree with Carl a little bit. I think that there have been a number of district judges that have been confirmed with bipartisan support, probably a number of appeal. I think the number of appeals court judges that on a strictly party line vote has probably been fairly few, even that. But as a general rule, I think that they've got a lot to overcome just for being nominated. And these Democratic senators get a lot of pressure, not to confirm someone and to try to leave the seat open, especially now. I think we'll see even more of it. But, they've never been up against somebody like Mitch McConnell before, who, this is really what he thinks is his most important legacy, and he is going to be very tough on that.
Well, and Charles said earlier, though, this used to be voice votes, and there would be no discussion of it all. In fact, I think Gorsuch was put on the circuit court by voice vote, as I recall.
I think that might be right.
And you don't have that now, but you have it for it's complicated reasons, and they changed the rules. But that's not only against the judge, the nominee, but it's also to use up Senate time and run the Senate clock. So part of the strategy is not only to oppose that judge, but to make in this case, the Republicans use a lot of time that they can't then devote to another judge. But they changed the rules, so you have it's a much faster pace now. And if you look at what the Senate is doing on any given day, it's nominations. And Mitch McConnell has already said that there will be no vacancy left unfilled by the end of January 2021. I mean, he's going to. I'm sure if he had to keep the Senate in around the clock, they would do it. Because you hear President Trump, he's always like, oh, Obama left us this great gift, and why didn't he fill all these vacancies? But he neglects to say that the Republicans refused to fill those vacancies.
And I think it's important to realize we're talking about Republicans here because they're the ones who have the power right now. Remember that Senator Obama voted against both Roberts and Alito because he disagreed with their ideology, and not because he didn't think that they were qualified. He becomes president. He wants all of his nominees to get an up and down vote because they're also qualified. I mean, I think there's few things that both sides are, less hypocritical about than judicial nominations.
Yeah, no,
I mean,
they both will do the same thing. I mean, you talk to, in my book, the Democrats who started this in some respects with the filibuster of Miguel Estrada. And in some ways that began this whole thing. Well, Harry Reid and Tom Daschle both say that was a bad idea, now that we think about it. And President Obama, as a senator, didn't just vote against Alito, he supported a filibuster against Alito. So, this is where when they change places, everything flips 180.
You refer to it as every day they're scaling the heights of hypocrisy in Washington.
Yeah, it's true. And doing it pretty straight-faced,
I want to spend, and you touched on this earlier, but I want to follow up on it. Some of the institutional changes that we pulled on, or potential changes that we pulled on, increasing the number of justices, limiting the time you could serve in office. Do those get serious discussion in Washington, in circles of people who are in a position to make change? What do you hear, Bob? I'll begin with you.
Well, I feel like that they've gotten more discussion, and there's more of a motivation behind them than I've ever seen before. Now, that doesn't mean they're going to happen, but I think, as Tara said, these were things that you didn't talk about before, and now they are getting serious discussion. I think she's right that term limits would be unconstitutional, or both of you said that, without, there would have to be some sort of constitutional amendment that would allow that. The number of justices is kind of an interesting idea. There's some people who actually thought 8 wasn't a bad idea because it meant that there had to be more consensus before, for instance, the court could strike down a law that had been passed by Congress. You would need 5 of the 8 instead of 5 of 9. I don't think the court thinks that that's a very good idea, and I think that the court really struggled during that. I think it was 16 months that there was only 8 members of the court, and it was a very tough time. They simply couldn't decide some things, or if they decided them in a way that made no one happy and didn't really answer the question that needed to be answered. So, probably you do have to have an odd number of justices, but, no one knows, as we discussed earlier, what the right number would be.
Are those serious?
Yeah, no, I think it's more serious. I think I agree 100%. It's more serious than I've ever been around, where people are saying, we're going to have to make some real changes. And there's progressive groups that are out there saying, we're only going to support a Democratic presidential candidate who embraces these things, and which would also require probably eliminating the filibuster entirely in the Senate. So you're talking, because the only way you would be able to move some of this legislation is if the filibuster was gone. So I think, you're talking about making that huge structural change in order to make some other ones. And, as what we've seen with all these things since I've been covering this, is that you do something on a partisan basis like that, and then when the other party gets in, they're going to try and undo it on a partisan basis, and sort of endless fights. But I think that there'll be more discussion in this presidential campaign about changes in the Supreme Court than we've experienced in the past.
I'm surprised the Republican senators haven't said, it's a great idea. Let's do it right now.
Yeah.
Interesting.
But they lost the House. So
yeah.
But the next time somebody gets lined up correctly, I think there's a good chance the filibuster goes.
We've looked ahead to the future a little bit in this conversation, but I think that's a good place for us to end. Maybe we'll come full circle. So 2020, the role of the court in the political campaign of 2020. as important as it was in 2016? More important? How will it be used as a campaign issue?
As a campaign issue?
Mm-hmm.
I think it'll be important. As I say, it'll be interesting to see if Democratic voters think that, the way Republican voters have in the past. I think it's important, too, that when we were talking about the court's legitimacy, to remember that a number of people thought, I was thinking back to a different presidential election I think you were going to ask me about, and the court's decision in Bush v. Gore, which some people said was the end of the court, would be seen as the end of the court as a neutral arbiter. And in fact, it wasn't that way at all. Their approval went up a little bit after that. And I think that there still is this belief out there that, the court will try to decide things fairly, and that the court's decision deserves respect. Now, maybe they will decide something that is going to break that, but we haven't seen it yet.
And Carl, you said that that there's the court, the discussion of the court helped mobilize certain Republican voters, conservative voters, but it's actually more specific, isn't it? It's kind of this niche of voters who are not necessarily all in on Donald Trump,
right?
But it's a smaller group.
Yeah, it is a subset, but they see the court as their last stand in some ways. And I do think it was important for him after Access Hollywood tape, right? This is a thing you would have thought evangelicals and others would really break from him, and there were some, but it didn't. They were like, this is a bigger thing than Donald Trump's bad behavior. And so I think it's going to be a big part of the campaign. I think whether or not there's a vacancy, and Mitch McConnell has already said pretty clearly that he wouldn't fill it. And I do think that if that occurs, and no matter whether it's a Republican nominated current justice or Democrat, I think that will inflame Democrats, and so that'll be a highly motivating issue for them. But Republicans also, as I said, they think those fights are good for their people. But as opposed to 2018, where the Kavanaugh fight helped them in some states where I actually think they would have won anyway, North Dakota, Missouri, Indiana. This time it's the Republican senators who are in trouble. They need independent voters. So it's like Cory Gardner, Martha McSally. So it could play differently for them. But I do think that if there's a vacancy, look out.
I was going to say, before we take the audience questions, I was going to come to you, Bob, with one final question, and that is that the people, I think, have this image in their mind that the court is this very divided body, that they don't agree on much. But you said, I think we were talking maybe even yesterday, they tend to be sort of protective of one another. That's one of the great myths, that the justices are at each other's throats, on a 24/7 basis.
That's true. They say very mean things about each other in opinions, and the reasoning that goes into them. But I did a story recently in which I said, once you're in, you're in. And I always sort of think of the court as like this family that likes to fight among themselves, but they don't like anybody outside criticizing them. And so what you've seen a lot, especially with Justice Kavanaugh and his trip to the court, you've seen Justice Ginsburg praise him at just about every speech that she gives for selecting only female law clerks, which meant for the first time last term that for the first time ever there was a majority of Supreme Court clerks were women. You saw Justice Kagan being asked about him at a forum, just shut down the questioner and said, this is an institution that I care about and I'm part of and I'm going to be on the rest of my life, and I'm not going to say anything that would undermine it. I mean, there is a real shared motive for them to have the court seen as above that, and so they're gonna stick together on those things.
Well, there's a thing in Washington, be careful what you say. You might need that person tomorrow.
Yeah.
So I think there's a little bit of that at work too.
Yeah.
Let's take a few audience questions. If you're in the lower seating bowl, press down on the microphone in front of you, the black device in front of you. If you're in the back, Eric has a microphone. He'll hold it for you, and we can take your question. Yes, sir. Yeah, just keep your finger down on it. We'll get it.
Thank you.
It's a way to shorten the question. You have to keep your finger
Wait,
down.
do we have a thing to cut that off?
Exerting pressure. I got it. The institutionalists were talking earlier in the day, and now we got the journalists here. So I thought maybe I could give you a hypothetical. From the standpoint of legitimacy, there's been a balance of powers, as the Constitution would define it. There's been some undermining of that recently in terms of the branches respecting each other's constitutional rights to do Congress, to check on the executive and so forth. How do you see that playing out if the same thing happens to the court? And I mean, you can take it to all kinds of extremes. I won't go there right now, but I guess my point is, just as Congress has been tried in terms of the subpoenas, a court decision that had some implications for the executive or the Congress would not be adhered to, or would be ignored.
Well, I think that's something we don't know if it would happen. We don't have evidence of that now. There are people out there, scholars, who say, it's within the president's power to ignore a court decision that he disagrees with, or to at least not to fulfill it exactly as the court has said. I don't know that would actually happen. But, I think that the court is aware of that, and that's one thing that I brought up earlier. A 5-4 decision that tells the president to do something he doesn't want to do might be seen very differently as a 9-0 decision telling the president that he has to do something he doesn't want to do. And so that's going to be a fascinating thing to see if the court has to make those kind of decisions.
I thought there was a chance it was going to happen with the census decision. They started making noise pretty quickly that they were going to go ahead, and I'm not sure how they were going to do that. This is a joke, but we have this thing in our Washington Bureau that it's a little thermometer, and it says constitutional crisis, not in constitutional crisis, right? And we kind of moved that back and forth. And I go, well, if the president defies the court on the census question, you can move it as far as you can into constitutional crisis. I wouldn't be shocked if something like that happened. There's a lot of things coming down the road here that I don't think the administration is going to want to comply with if it was so ordered. And, I was just looking at some of the news breaking today, and there's always so much news breaking. And Russ Vaught, the head of the OMB, openly defying, saying, I will not respond to these subpoenas or be interviewed. At some point, that's going to get somewhere with the court, so we'll have to see how it plays out. I honestly hope it doesn't happen, because I think it's very, very dangerous.
And there was just speaking of things that just happened, I just got a note that one of the cases in which, and this is the New York case in which a prosecutor wants to see the president's tax returns. They've come to an agreement that whatever the court rules, it won't go into effect for 10 days because the administration has said if it goes against them, they're going to go to the Supreme Court with it. And so, it seems likely that those kind of issues are going to get there.
And then, as I said earlier, then what happens if the 5 Republican nominated justices go solidly with the president, gets the 4 Democrats? Then I think you have people who are going to look at this and wonder about the legitimacy of the court, which we're sitting here talking about.
Let's take other questions. I'm going to go back here. Eric, you want to wait for the microphone, and we'll let you ask your question.
Hi. So a question I wanted to ask this morning when the professors were talking, I think maybe comes back now, and it's talking a lot about how judicial behavior shapes public perception of the court. And I'm wondering, because so much of the public's understanding of what the court does is going to be mediated by the press and by political conversation, and because I so frequently see the press getting the law wrong when it reports on judicial decisions.
Guilty.
So how, I guess,
he gets it right.
Double-pronged question, to what extent does judicial behavior, or how effective is the press at transmitting the nuances of what the judges are doing in order to shape public perception? That's part one. And then part two is, how much control do judges have of how the press represents the actions that they take?
Well, as to the last one, they don't have any control, which I'm sure they wish they did, partly because they might think that they do a better job of getting us to say what it does. I think that nuance does get lost. There's no doubt about that. I think nuance is also available for anyone who wants to know it and to access it. And, one thing we haven't talked about here is it's not just the press or media, meaning the two of us and our organizations, that translate what the court does for the public now. It is very active on social media. There are blogs and organizations on both sides of the political spectrum that write about the court all the time. And, you can almost, set your watch by a decision comes out, and you're going to get an article from this side saying this is the worst decision, this is the biggest threat to the Constitution that's ever come across, and another one saying, finally, the court has stood up for the Constitution. And so it's not just us who get to filter that news anymore. It's a much bigger universe out there.
Yeah, which I actually, in some ways, is good. There's more coverage of these things. I think like Adam Liptak, who writes about the court for us, I mean, they're great. They really explain these cases and understand it. But the news business is not often the nuance business. And I just think you people as professional practitioners of the law or students, you're going to see stuff you go, well, that's not exactly right. And they're trying to explain it to their best of their ability. I don't think anyone's out there, certainly in our kind of media landscape, trying to subvert these decisions or whatever. Whether they understand all the fine points of it is a different thing. But the people who cover the court on a daily basis do a phenomenal job. And now they have to do it a lot faster than they used to do it. It used to be you could kind of cogitate on that opinion all day and sort of write out a nice big story explaining it all. Now you have to do it in about 2 minutes. So it's
also tweet about it.
Yeah, while you're tweeting about it, right?
Yeah.
So it's a whole different animal.
Yeah. Other questions?
This man's been trying to.
Oh,
and he's,
sure.
and
Bruce,
he's smiling.
He's smiling. He's still smiling.
Yeah.
Thank you. Often when you see an article written on a court decision, at the bottom of the article is a breakdown that says, this judge was appointed by a Republican and this judge by a Democratic, sort of leaving the impression that you vote for who you like. But what you don't see is an analysis that says this judge voted in a different way on a similar case that maybe Obama was involved in. Or, the question is, are they acting as partisans or are they following principles? And I guess you mentioned the 3 judges who voted to allow I think it was New York, to get Trump's tax. I think it was actually a 2-to-1 decision. The one was somebody appointed by Trump. The question, I guess, is there a way to separate the two questions? Are they making the decision because it's Trump, or are they making a decision because they believe in a certain principle?
I think that's a controversial thing, and I don't have the answer to it, to tell you the truth, as to whether we should do that or not. There are some reporters who cover courts who think that it's not relevant information and shouldn't be in your story. I can tell you readers ask me that question all the time and want to know who nominated that person. You know, I use it when I think it's relevant, when I think people are really going to want to know, or when it shows a pattern. For instance, voter ID laws and whether or not voter ID laws are constitutional or not. If you go back and look, you will see that almost every judge who was appointed by a Democrat has a problem with them and thinks that they are unconstitutional or a problem, the way they've been implemented. Republican judges almost always uphold them. And so I think when there's a relevant pattern like that, you know, it sort of shows. And I get sometimes conservatives, when President Trump's initiatives have been knocked down in the lower court, saying they're all Democratic-nominated judges who are doing that. Why don't you say that in your story? And so, you know, it's kind of tough to figure out where you should be on that question, I think.
Yeah, I luckily, that's above my pay grade, so I don't have to make that decision at work. But I think that the basic place that a judge came from, which is which the president was in what party, is often relevant to the way, at least that those people at the time knew what the president was looking for. Not that it was bad or good, but just that kind of approach to the law. So I see that it's a potential problem. In so many cases, I mean, that's the thing about the courts, and the judge knows this, so many cases don't have political or partisan sides at all. But I think it's just one of those pieces of information that we're going to include. But it probably does sort of build in this public unease about the courts.
I think I'm going to wrap things up there. Before we go, just a couple of things. If you've been interested in what Carl Holtz has been talking about today, he will be back with us tomorrow at 12:15 for an On the Issues event here. We'll be talking at length about his book on the Supreme Court, confirmation bias, and we'll touch on the events in Washington. I said that would be an hour or two by itself, but we'll try and squeeze it in the hour tomorrow. I also want to thank Carl and Bob Barnes for being with us today. I think they did a terrific job. And finally, on behalf of Marquette University Law School, I want to thank all of you who came to this event today. Charles' numbers were fascinating, I'm sure, for all of us, and we appreciate our panelists being with us who did a terrific job. Thank you all so much for your time, your interest, and your attention. Thanks for being with us.